Critical grant programs rely on the Crime Victims Fund, which continues to experience historically low deposits. I look forward to continuing to work together to ensure that the Crime Victims Fund remains solvent, and welcome a discussion today about how the department is pursuing both short and long-term solutions to ensure the Crime Victims Fund remains a dependable source of funding for survivor resources. As we said earlier, I also look forward to working with the department as we look at the resources for the Antitrust Division to ensure that they can continue to do their work. Now, before I close, I want to thank the over 116,000 career employees of the Department of Justice, including law enforcement personnel, intelligence analysts, and attorneys, for their tireless work each day to keep Americans safe. Their work's not easy, but it's vital to our country, and I'm grateful for their service. Mr. Attorney General, I look forward to your testimony in our discussion today, and I will submit my full statement for the record. And now I'd like to recognize the subcommittee ranking member, Senator Moran.
Chairman Shaheen, thank you very much. Thank you for convening this hearing, and thank you for the cooperation that you've exhibited with me and this side of the dais. I enjoy working with you, and I look forward to doing so in this new fiscal year. The complaint yesterday in a hearing was, well, you did get your appropriation bills done, but they were 6 months late. So maybe we can get them done and get them done on time.
That would be refreshing.
And would be a great cut. We reduced the spending in the Commerce, Justice, Science arena by $2.5 billion. And we'll work to see if we get a good and fair allocation to hopefully make things slightly different and better in this fiscal year. This hearing is timely and critically important. Kansans, in fact, all Americans are facing extraordinary threats to their security, both from threats here at home and abroad. And the Department of Justice is an integral component of addressing those challenges. First, President Biden's failures at the southern border has led to a national security and humanitarian crisis with grave repercussions. We've lost our ability to manage and in some cases even know who's crossing our borders. That includes agents of foreign powers, potential terrorists, and others who mean to undermine our institutions. Additionally, it's well established that most of the illicit fentanyl in this country was flooded across the southern border by Mexican cartels. I hope to hear how the department plans to disrupt and dismantle these cartels and their distribution networks. Second, events in the Middle East, including Hamas's vicious attack on October the 7th on Israel, and Iran's support for proxy forces, and now their own actions have dramatically elevated the risk of terrorist attacks in the United States. We face serious threats of coordinated attacks, as was just seen, it happened in Russia. Third, violent crime continues to plague communities across our country. Modest declines in the FBI unified crime reporting statistics mean little when compared to the experiences people across the country have encountered and been harmed or traumatized by that crime. The DOJ's own reporting, the National Crime Victimization Survey, showed that total violent crime victimization rose in 2022. Finally, cyber capabilities of our enemies are continuing to improve, putting our system at greater risk. Foreign adversaries, including China, Russia, and criminal gangs that operate under the support and protection are targeting municipal drinking water systems, business small and large. In fact, Mr. Attorney General, our state's judicial branch was subjected to a cyber attack that was certainly disabling for a significant number of months. And the agricultural interest in Kansas, our industry in Kansas, has had these experiences as well. Virtually every aspect of modern life depends upon the networks and systems our adversaries are targeting, and the threats cannot be understated. We live in a dangerous world, Attorney General, as you well know. I was with the FBI director in Kansas 10 days ago, 2 weeks ago. He expressed, it was a cybersecurity conference, he expressed that, quote, he would be hard pressed to think of a time where so many threats to our public safety and national security were so elevated all at once. Those are challenges that your department faces every day. I wish them success, and I wish to be helpful in making certain that we're able to address and reduce those safety and national security issues. I hope this conversation that we have today will instill confidence in the American people that the Department of Justice is working to address threats like these and to make our world, our country, our communities a safer place. Chair Shaheen, again, thank you, and Attorney General Garland, thank you again for being with us. I look forward to hearing your testimony.
Thank you very much, Senator Moran. Mr. Attorney General, the floor is yours.
Thank you, Chair Shaheen, Ranking Member Moran, and distinguished members of this subcommittee for the opportunity to discuss the Justice Department's funding request for fiscal year 2025. Since I last appeared before you, the public servants of the Justice Department have continued to advance our mission to keep our country safe, to protect civil rights, and to uphold the rule of law. Our U.S. attorneys' offices, law enforcement agents, and grant-making experts have worked together with police and community partners across the country to help drive down violent crime. We have gone after the cartels that traffic in deadly fentanyl. We have prosecuted fraud, recovered stolen funds, and challenged illegal monopolies. We have investigated and prosecuted hate crimes that terrorize entire communities. We have worked to defend the reproductive freedoms that are protected by federal law. We have worked to combat a disturbing spike in threats of violence against those who serve the public, including judges, police officers, senators, and even against our own employees. And in everything we do, we have worked to ensure the equal protection of law that is the foundation of our democracy. I am proud of the work we have done, and I am deeply proud of the way the department's public servants, from our agents to our attorneys to our administrative staff, have gone about their work. They have conducted themselves in a way the American people should be proud of. But we recognize that we have much more to do. Our fiscal year 2025 budget request reflects the difficult budget environment that we are in and the extremely difficult choices that we had to make because of it. It also reflects the resources that we need now more than ever to continue our work. When I became Attorney General 3 years ago, I knew that grappling with the violent crime that surged during the pandemic would be one of our greatest challenges. I am glad to be able to report that last year we saw a significant decrease in overall violent crime compared to the previous year, including an over 13% decline in homicides. That is the largest one-year drop in homicides in 50 years. And data indicates that this decline is continuing. As a Wall Street Journal recently reported just this week, in the first 3 months of this year, homicides dropped 20% across 133 cities as compared to the same period last year. But I want to be very clear. There is no acceptable level of violent crime. Too many communities are still struggling. Too many people are still scared, and the hard-fought progress that we are seeing can easily slip away. We must remain focused and vigilant. To continue to help keep our country safe from a range of threats, we are seeking a total of $21 billion to support the FBI, ATF, DEA, U.S. Marshals Service, and the U.S. Attorney's offices, as well as the Criminal Division and the National Security Division. We will use these resources to prosecute illegal gun traffickers and straw purchasers, to invest in the advanced technological tools that help us fight gun violence, and to hold accountable the cartel members and leaders and associates who are responsible for poisoning our communities with fentanyl. We will use these resources to counter the threats that the governments of Iran, Russia, China, and North Korea pose to our country. And we will use these resources to strengthen our work to counter both foreign and domestic terrorism. As the FBI director has testified, we are facing an increasing threat of foreign terrorism since October 7th. That is why the department also urges the Senate to act to reauthorize Section 702 of the Foreign Intelligence Surveillance Act, before it expires this Friday. As you know, Section 702 is indispensable to our work to protect the American people from cyber, nation-state, terrorist, and other threats. In addition to our own prosecutorial and investigative resources, we also recognize the importance of our partnerships to help keep our country safe. So we are seeking investments in the department's 3 grant-making components: the Office of Justice Programs, the Office of Community-Oriented Policing Services, and the Office on Violence Against Women. They support community and law enforcement partners through more than 200 grant programs. Our budget requests more than $4.3 billion to support the public safety efforts of our state, local, tribal, and territorial law enforcement and community partners, including $2.5 billion for the COPS program. And as part of our effort to administer safe and humane federal detention and prison systems, we are requesting $8.8 billion for the Bureau of Prisons. That includes resources to address urgent staffing and infrastructure needs. As I have noted many times before, when the Justice Department was founded in 1870, one of its principal purposes was the protection of civil rights. Protecting both the safety and the civil rights of everyone in our country remains our urgent obligation. Our budget seeks $201.3 million for the Civil Rights Division to continue its essential work, including to deter and prosecute hate crimes, to ensure constitutional policing, to enforce federal laws prohibiting discrimination in all forms, and to protect the right of all eligible citizens to vote and to have that vote counted. The right to vote is the cornerstone of our democracy. Protecting that right requires us to protect the citizens who we rely on to fairly administer our elections. Our democracy cannot function if the officials, workers, and volunteers who administer our elections have to fear for their lives just for doing their jobs. The Justice Department is aggressively investigating and prosecuting those who threaten election workers with violence, and we will continue to do so. As I said, I am extremely proud of the work of the department's employees, the work that they are doing to advance our mission. Their work brings them face to face with some of our country's greatest challenges, and many of them risk their lives to protect the public. I am grateful to them, and I am honored to be here to represent them. I respectfully ask for your support for the President's FY 2025 budget requests so that we can continue our work on behalf of the American people. Thank you.
Thank you, General Garland. The Vice Chair of the full committee has arrived. Senator Collins, would you like to make any opening remarks before we start questions?
Thank you very much, Madam Chair. I'll wait and ask questions. Thank
Okay.
you.
Thank you. We will call on members in order of arrival, with the exception of Chair Murray and Vice Chair Collins, and ask that people keep their questioning to 5 minutes, except for the Chair and Vice Chair. And we will alternate between sides of the dais and sides of the aisle. So, Mr. Attorney General, we are now, as I said in my opening statement, painfully aware of the impacts of the Fiscal Responsibility Act and what that means. I cited the example of FBI in terms of the percentage cut, but what that actually means in terms of dollars. What will happen at the department, particularly to the law enforcement components, if it faces similar cuts in 2025?
Well, I obviously quite agree with you. Overall, as a consequence of FY 2024 budget, we anticipate needing to reduce a total of 4,813 positions. And that's not specifically about law enforcement, but I will move to that in a moment. The 2025 budget that we're requesting seeks to restore 1,409 positions. Specifically, with respect to law enforcement, between 23 and 24, we lost 200 agents in the positions in the FBI. Our request is an increase of 217 agents, which is, as you can see, is only 17 more agents that we had in FY 2023. For the U.S. Marshal Service, we lost 72 deputy U.S. Marshals positions. We are asking now for an increase of 51, which includes what we need for purposes of the increased requirements for security for the justices. The U.S. attorneys between FY 23 and FY 24, which of course bring our criminal prosecutions, we lost 188 positions for assistant U.S. attorneys. We are asking for 50 over FY 24, which of course does not make up that number. I can go through the whole number if you'd like, each of you'd like, but you can see that we are, in most cases, we are not going to be able to make up even for what we lost between 23 and 24. But we are doing our best to be faithful to the congressional statute and to the bipartisan agreement.
Well, I appreciate that. I think as we know, the challenge is that there are very real impacts for these budget cuts, and they will have an effect on the public and on our ability to address all of the issues that the Justice Department is working on. Senator Moran and I both mentioned in our opening statements, as did you, the continuing fight against the opioid epidemic, substance misuse, the drug cartels. I continue to be very concerned about fentanyl use and poisoning. New Hampshire has lost too many people to fentanyl overdoses. Can you talk a little bit about DOJ's efforts to interdict these drugs and efforts to find a way to prosecute those responsible?
Yes, Senator. I have said, and I deeply mean this, that fentanyl is the deadliest drug threat that this country has ever faced. I've met with families at the DEA whose children, whose teenagers, whose infants, whose grandparents have died, mostly not even knowing that what they're taking is fentanyl, thinking it's another kind of prescription pill that they were able to get over the internet. We don't even refer to this as overdoses anymore, we refer to this as drug poisoning, because that's what it is. So we are facing this with the urgency it requires. And we are trying to dismantle the entire network. So the network begins in China. It begins with the precursor companies that sell the precursor chemicals that are necessary to make fentanyl through Mexico. So we have charged a number of those companies. We have indicted a number of their officials. We have even been able to snare some of them, the officials, when traveling outside of China. The Treasury Department has sanctioned those companies so people cannot deal with them. Some of them are regular prescription drug companies, so sanctions are quite important. Then we move to Mexico and the importation of these precursors. I've traveled to Mexico myself 3 times, the Deputy Attorney General, I believe at least 3 times. Many other parts of our law enforcement apparatus have done the same to persuade them to cut off access to these precursors, to register them. And they have done some of what we've asked, not all, but that has been important. Then the chemicals are made into fentanyl in Mexico, primarily in laboratories. We have, again, on my visits, we have urged the Mexican government, and particularly the Mexican military, the Army, and the Marines who are responsible, have taken over this task to destroy those labs, and they have done some, but not as much as we would like. We have indicted the principal cartel leaders, including the sons of El Chapo, the so-called Chapitos of the Sinaloa cartel, as well as leaders of the Jalisco New Generation cartel. Those 2 are the principal drivers of fentanyl trafficking in the United States. On one of my travels, I urged the Mexican government and the Attorney General to approve the extradition. And in fact, they did approve the extradition of Ovidio Lopez, Guzman Lopez, who was the lead Chapito. Then
Mr. Attorney General, I know you could probably
Oh,
go
I'm
on, which is
I
very helpful.
apologize.
We would like to talk all day about what's being done to address this. Out of time, but I also have one very brief follow-up, and that is, you mentioned going after the precursors in China.
Yes.
Are you seeing any difference at all since President Biden and Xi signed their agreement around dealing with those drugs back last fall? Has there been any change in the way China is reacting?
Yeah, we've seen some, but nothing like what we want or expect. The president says the words are nice, but we need to verify. And at this point, we don't have very much verification.
Thank you. Senator Moran.
Chairman Sheen, thank you. Let me visit with you for a moment, Attorney General, about AI and our national security risks. Both Congress and the Department of Justice are grappling with the opportunities and threats that are presented by the rapid development of artificial intelligence. 2 months ago, the department appointed its first chief AI officer. Yesterday, my colleagues and I, we were in a letter trying to bring the risks of AI to the attention of other colleagues of ours. We specifically are targeting the potential catastrophic risks associated with the use of AI in the development of biological, chemical, cyber, and nuclear weapons. I'm looking for assurance that the department is and will pay sufficient attention to these extraordinary threats to our national security. And I would welcome your thoughts about what's happening in the new AI office, as well as other DOJ components with national security responsibilities. What's happening to consider and mitigate the national security risks and other catastrophic risks created by AI?
Yes, so AI has both promise and incredible peril for us. As is often the case in the beginning, offense beats defense here. And we are very concerned about the way AI can be used for everything from mimicking normal conversations in text, and therefore advancing the ability to do phishing expeditions by getting passwords from people, by using their social media to appear as if they are a friend, and likewise just plain hacking and constantly and repetitive hacking in a way that clicking on the keyboard will seem very 20th century. So we are extremely concerned about that. AI has some possibilities also for defense. Instead of having to defend constantly with human actors, someday we hope to be able to develop an AI defense to the cyber attacks that you're talking about. This does require us to enhance our AI capabilities. That's why I recruited the AI head that you're talking about. He's a PhD in computer science, who teaches computer science at Princeton, got his PhD in Stanford. We are looking to hire as many people with those kind of qualifications as are possible. And that's why we're asking for the money that we're asking for specifically with respect to cyber. We're asking in this budget for $894.6 million, which is an 11.9% increase in our cyber crime combat, and a $432.9 million increase specifically with respect to cybersecurity, which is 15.6% increase.
Thank you for highlighting those. Let me turn to a different topic. Last week, I was disturbed to see an NBC News report that an individual on the terrorist watch list had been detained by the Border Patrol on the southern border and then promptly released. The facts of this case are complex, they're nuanced, but according to the report, when the detainee appeared before the immigration judge, the DHS attorneys did not inform the judge of the potential terrorist ties, despite having received that warning from the FBI. The judge ultimately ordered the detainee to be released. I don't expect you to be able to respond to the actions of the Department of Homeland Security, but again, I would look for assurances that through the FBI, the Terrorist Screening Center, the immigration courts are taking the necessary steps to ensure suspected terrorists are not simply released into the country. You talked about the increasing terrorist threat to our country. My last trip to the border, there were nationals, Chinese nationals, who were apprehended in my presence. I see this as a significant threat, and I just want really to highlight this issue to the FBI and to the Department of Justice, making sure that you're doing your job.
Yes, the FBI's job, and they take it extremely seriously, is when they learn information about somebody who has been able to pass through the border, to follow that person, to deter that person, to disrupt that person, and to arrest that person where we can. In the example that you're talking about, that person has since been detained. And we are constantly in discussions with the Department of Homeland Security about how to improve the processes between Homeland Security and the immigration courts and at the border with respect to terrorist screening.
Thank you, General.
Senator Heinrich.
Thank you, Chair. Attorney General, as you know, Vice Chair Collins and I worked very hard on a number of provisions in the Bipartisan Safer Communities Act with respect to both straw purchasing of firearms and then also gun trafficking offenses. Can you give us an update about how the department is using those new offenses and what progress you're making on that front?
Yes, I'd be happy to. So that act is really the most important gun legislation in decades, and has already had significant impact on our ability to prevent guns from falling in the hands of people who are prohibited by Congress from obtaining them because of their dangerousness. So as a consequence of the act, which extended the background checks for people under 21, we have been able to run 245,000 enhanced background checks, and we have denied 700 transactions, which otherwise would have gone through. 700 people who should not have guns because Congress has so declared. And with respect to the straw purchasers provisions, we have charged more than 420 defendants now with illegal straw purchases under provisions of the BISCA and associated statutes we have on straw purchasing. So I'd say it's early days, but
Yep.
It's been very effective.
Yeah, we definitely want you to be able to use those authorities. What about the gun trafficking authority? Has that been helpful as well?
Yes, the gun trafficking allows us a separate crime and a separate penalty for trafficking guns where it's known that the guns are going to be used in crime, and those have also led to successful prosecutions.
I want to turn to fentanyl, and obviously that's something that's on everyone's mind on this panel. One of the things that I worked very hard on in the recent 24 CJS bill is language to create a comprehensive fentanyl tracking system. Can you tell us what you intend to do? I know we got that legislation done a little late, as Senator Moran reminded us, but we want you to be able to use those authorities and tell us about how you plan to put that together.
Well, so DEA will be using that to track the way in which fentanyl is prescribed and used, and that will be very important in our enforcement efforts.
Are you able to coordinate your efforts with DHS to help interdict fentanyl when it comes through land ports of entry before it gets to the U.S.?
So the FBI and DEA do have overseas intelligence, which they're able to provide to DHS. I will say this also comes from our intelligence community writ large, and not simply the two agencies here. It is definitely the case that the more intelligence we can get and the more cooperation we can get from the Mexicans as to their information about fentanyl being moved to the border, the better DHS will be able to interdict it at the border.
How can Congress help you leverage better cooperation from both Mexico and China on this front?
Well, I'm not a diplomat, so on that phase, I'm not sure what Congress can do in this regard, but we are making every effort possible. The DEA administrator has spoken to her counterpart in China The president, as you know, tried to re-up the cooperation that had been suspended with respect to drug trafficking. At a law enforcement level, we are trying to enhance that. On the Mexico side, as I said, the president has directed members of the National Security Council staff to travel to Mexico. I've traveled, the Deputy Attorney General has traveled to try to enhance cooperation and get improvement in it.
We very much appreciate those efforts. I want to ask you about something related to treatment for folks who know they have addiction to fentanyl and other opioids. Can you talk about what DOJ and DEA are doing to increase access to treatments like buprenorphine for patients in need? And this has been a particular challenge in New Mexico, where people want to get treatment, but they can't always get their prescription filled to get off of their fentanyl addiction. And I'm curious if you think it's necessary to remove medications like buprenorphine from the suspicious order reporting systems, because that seems to be the thing that is hanging up these prescriptions for people who are very much wanting to get treatment.
Well, to begin, this mostly comes from our grant programs, from the Office of Justice programs. We have the so-called CARA grants, which is the Comprehensive Addiction and Recovery Act. We're asking in this budget for $443 million, which is a $23 million increase. Those grants include our Comprehensive Opioid Stimulant and Substance Abuse Program, so-called COSAP program, mental health and residential substance use treatment, drug courts, veteran treatments courts, prescription drug monitoring. We also have particularly youth-focused grants, some seeking $47 million there for opioid-affected youth. I'm not exactly sure that I have the information with respect to Butte and how it's being treated in that respect. So I'll have to get back to you on whether.
Yeah, I look forward to following up with you on that, because I think we need to send a clear message to the pharmacies that they should stock the medications necessary for treatment. Thank you, Chair.
Thank you, Senator Heinrich. Senator Collins.
Thank you, Madam Chair. Welcome, Mr. Attorney General. I very much appreciated hearing the update on the effectiveness of the straw purchasing and gun trafficking provisions that Senator Heinrich and I authored. And so I won't have to ask you about that issue. I do want to turn to a very serious and confounding problem that the state of Maine is experiencing, particularly in our rural communities. Chinese nationals are establishing and operating illegal marijuana growing operations. I first raised concerns about this problem in June of 2022. Thanks to the work of some enterprising Maine journalists, we now know that there are more than 200 such operations operating in houses across our state. And by the way, those houses are forever ruined by the operations, and that contributes to our housing shortage as well. Last month, I asked the FBI director about this matter during his open testimony before the Senate Intelligence Committee. While the director cited the FBI's efforts to support task force and secure indictments, he was unable to answer a fundamental troubling question, and that is, why is China sending its citizens, sneaking them into the country to open illegal marijuana operations in rural Maine communities? Just recently, 3 Chinese nationals were apprehended as they crossed the border illegally in northern Maine. Now, we've had a tremendous effort by state, county, and local law enforcement to identify and start shutting down these illegal operations. But there are very clear federal interests here. particularly with respect to national security. 2 days ago, your Office of Legislative Affairs finally responded to 4 inquiries that I had sent to the department on this topic. But unfortunately, the response letter provided almost no substantive information on whether the department is making this a priority, working with state, local, and county law enforcement, and exploring the national security implications. And I do recognize there's a limit to what you can say in a letter of that sort. But General Garland, what are the Criminal Division, the National Security Division, and the U.S. Attorney's Office in Maine doing to address these illegal growing operations? And in particular, what are they doing to support the tremendous but under-resourced effort at the state, county, and local level?
Senator, you've raised a serious problem. It's not only a Maine problem. So DEA is reporting that there are transnational criminal organizations in some 20 states that are, it's not so much grow houses, but illegal marijuana grows. I know specifically with respect to Maine that DEA and the FBI are working with the IRS and the Department of Homeland Security as well as local law enforcement to investigate those illegal grows. I also know that the U.S. Attorney in Maine has made this a priority for her office. In most cases, I recommend talking to the Office of Legislative Affairs, but I know you are very well synced up with U.S. Attorney's office there, and they obviously have more very specific Maine information. But I don't think anybody could take this more seriously than our U.S. Attorney there. And she is able to harness the resources of all of our agencies, not only our own, but also Department of Homeland Security and IRS.
Do you have a theory on why the Chinese are sending people illegally into our country to establish these grow operations? As you point out, it's not just Maine. I believe Oklahoma, for example, has had a problem as well.
I don't have a theory now. Normally I develop a theory by learning the facts from the different investigative entities that look into this. So at this point, I don't have a theory. There are a lot of obvious theories, including profit motive, and these transnational criminal organizations are operating. The reason we call them transnationals, they're operating all over the world to make money where they can. But I can't tell you what the specific motivation here is.
Thank you.
Thank you, Senator Collins. Chair Murray.
Well, thank you very much, Chair Shaheen and Ranking Member Moran for holding this hearing today. Thank you, Attorney General Garland, for joining us. We all want to make sure that folks back home have a fair, functioning justice system and safe communities, which is why we have to make sure DOJ is getting the funding that it needs. Effective law enforcement is crucial to protect people from cyber attacks, drug trafficking, gun violence, and so much more. And it's critical in holding big corporations accountable for cutting corners and engaging in unfair practices that hurt our consumers. And DOJ's work is vital to fighting bigotry and discrimination and protecting people's civil rights, including the right to vote. So we cannot shortchange America's rights or their safety. That's why this hearing is so important. Attorney General Garland, I am really encouraged by the investments your department has made in Eastern Washington, like marshaling new resources and investing in personnel to help combat the crisis of missing or murdered Indigenous people, especially women and girls. DOJ recently launched an MMIP regional outreach program, which allowed our U.S. attorneys for Eastern Washington to add an assistant U.S. attorney to their office who is dedicated to prosecuting those types of cases in the Northwest. How would the resources that your department is now requesting for FY25 build on those efforts?
Yes, I'm This problem of missing or murdered Indigenous persons is really brought home to me. I visited the Alaska Native villages with Senator Murkowski, and I recently visited the Crow Reservation in Montana. But this is a problem all across Indian country, and we take it very seriously. And in our budget request, we've asked for $713.2 million for this program for public safety in Indian country, to include money that we need for FBI, for U.S. attorneys, and for money for the local law enforcement.
Thank you. I appreciate that request. We look forward to working with you on that. The Crime Victims Fund through VOCA accounts for nearly 70% of all of funding for services that help victims and survivors of crime. In Washington State and in tribal and rural communities, those programs rely solely on VOCA funding. But we know that deposits into the funds have declined recently and have not kept pace with the need, which has led to cut to service providers in Washington State, meaning less help for victims and survivors, especially in our underserved communities in rural areas and on tribal lands. Can you talk a little bit about the importance of those programs and the Crime Victims Fund as part of the department's effort to promote public safety and support victims of crime?
Absolutely. This is an issue that is particularly dear to my heart, since in the aftermath of Oklahoma City, I spent a lot of time trying to improve the way in which the Justice Department, both itself, deals with victims of horrendous crime, but also helping state and local law enforcement and communities deal with these problems. So our money for OVW grants this year, we're asking for $800 million for the Office of Violence Against Women. The total amount we're asking from the Crime Victims Fund is $1.5 billion total, which is an increase of $147 million over enacted FY24. The victims' money goes to a significant number of different places. Goes to the grants to combat violence against women, the so-called STOP grants, the sexual assault services grants, legal assistance programs for victims, transitional housing, the access to sexual assault nurse exams, culturally specific services. I can talk more about the fund if you want, but
I think that it's just important for all of us to understand the really critical importance of those funds as we work to put our budget together. So thank you. I wanted to ask you about the Federal Bureau of Prisons facility at SeaTac. We had recent reporting from the Seattle Times that found that detainees were routinely unable to access basic medical care and treatment for acute and painful conditions. And according to their reporting, 8 of 19 healthcare positions at the SeaTac facility are now vacant. That no doubt contributes to those issues. What is the department doing to improve access to care for individuals in their custody, and what steps is the department taking to recruit additional healthcare staff?
So the Director Peters, has stated from the very beginning that BOP considers itself a healthcare organization, given how many people need healthcare who are imprisoned. The SeaTac Federal Detention Center has strengthened its recruiting efforts and has contracted for several more medical professionals recently. In the last 6 months, it has tripled the size of its opioid treatment program and provided more routine and chronic care. I think that the director has gotten the message with respect to the deficiencies there.
Okay, and I'm going to be following that very closely, so I expect to be updated on that as we go. And finally, let me just ask you about help for at-risk youth. I continue to hear from communities all over my state about the need to do more to help at-risk youth avoid delinquency and provide better opportunities for them. It is really important that the department's juvenile justice programs serve the youth that end up in this system and allow those kids to realize their full potential. This is an effort that we all know requires coordination across nonprofits and state and local leaders in the federal government. So can you tell me how your budget request would support justice-involved youth?
Yes, so specifically on that question, we're seeking $407 million for juvenile justice initiatives, which is an 8.5% increase. This includes $3 million for a new collaborative reform for juvenile justice initiative for localities that are facing particularly serious juvenile issues.
General Garland, excuse me for interrupting. Can you just pull the mic a little closer so that
sorry.
people can hear better?
Is that
Thank you.
better? I'm sorry. Yeah. The total budget we're requesting is $690.8 million to protect children in a variety of programs, Office of Justice Programs grants, the Office of Justice Programs Stop School Violence grants, and the other matters that I've already mentioned.
Okay, this is a critical program and we continue to be looking at that. So thank you. Thank you, Madam Chair. I appreciate it.
Thank you so much, Chair Murray, for joining us, and Senator Kennedy.
Thank you, Madam Chair. General, nice to see you again. Thank you for being here. Your current budget, by my calculations, is $48.3 billion. Is that right?
The budget request is for $37.8 billion, the FY25 budget, and that would constitute a 3.5% increase over.
But with mandatory spending, your budget's 48.3. Is that right?
I don't have the number for including mandatory, but I'll certainly be able to get
Okay.
back to you for that.
Well, let's take out mandatory.
Yeah.
Your discretionary budget right now is $37.8 billion.
The FY25 request is for 37.8.
That's not what I'm asking.
I'm sorry?
What's your current budget?
Well, it's 3.5% less than that, so I can take out my calculator and do the math, but I don't have it in front of me.
All right, well, let me put it another way. You're asking for an extra $467 million, is that right?
In the increased amount of money that we're asking for, that's approximately right, yes.
Okay. To your knowledge, in the past, let's say 40 years, has the Department of Justice ever come before Congress and said, we don't need any more? We're going to make it with what we've got in light of the fiscal circumstances in the country?
I normally wouldn't want to speculate, but in this case, I can't imagine that the Department of Justice, facing increasing threats every year, violent crime, threats to our national security, drug trafficking threats.
Is that a no?
I don't know the answer, but I think it would be surprising if the department ever asked for less money. I think that
Okay.
would be not responsible.
You talked in a little bit in your testimony, General, about guns, and you've been very outspoken about the need for more gun control. With respect, and if you don't mind me asking, do you own a gun?
I don't.
Okay. Have you ever fired a gun?
Many times.
Okay. Do you have 24-hour security?
I do.
Okay. Let me ask you about fentanyl, because that's a huge problem, and I know you're worried about it, as are we. And we've, of course, got a problem with the precursor chemicals coming into Mexico to the Mexican cartels who manufacture the fentanyl and send it into the United States. Isn't a big part of the problem that if you took the Mexican drug cartels and turned them upside down and shook them, that President Lopez Obrador would fall out of their pockets?
Well, I'll leave the metaphor aside. The department has said that we do not have an investigation of the president of Mexico.
Do you think President of Mexico is our friend?
We need cooperation from Mexico. Mexico has been somewhat cooperative with respect to our fight against the cartels, not as helpful as I wish they were, but without their cooperation, we can't be successful in destroying the cartels.
Why wouldn't the president go to President Lopez Obrador and say, no offense, but the fentanyl problem is killing Americans. The illegal immigration problem is hurting Americans. If you don't cooperate with us, and he clearly hasn't been, and he's not afraid of us, we're going to implement tariffs on Mexico until you do.
I think there are many ways to encourage cooperation from another country.
But that would do it, wouldn't it?
I don't know whether that would do it or whether.
You don't think that would get his attention?
I am not a diplomat. I'm not a foreign affairs strategist. I know we need their support and cooperation.
Yeah.
I don't know whether that would be positive or negative.
So we just ask politely.
Well, we do more than that, but
Right.
considerably
Right.
more than
Let
that.
me
I
ask-
don't know the answer to your
Okay.
high
Let me
level
ask you one
strategy
last question in my 14 seconds. I've been dying to ask you this question.
How long have you been dying to ask me this question?
Long time, long time. Mr. Hunter Biden did not pay taxes on $1 million in 2014 and 2015. And he deducted payments from his income tax for personal expenses when he did file. For hookers, for a Lamborghini, for strip clubs, for sex clubs, for porn website memberships. Why did the Department of Justice let the statute of limitations run?
As you well know,
So you
Senator,
can't prosecute?
as you well know, Senator, that investigation is being conducted by Mr. Weiss, who was appointed by President Trump to be the U.S. Attorney in Delaware. Much of the investigation you're talking about occurred during the previous administration under Mr. Weiss. Mr. Weiss has continued his investigations. It's now a special counsel. He will issue a report which
So are
will
you saying
explain
it's
those,
Trump's fault?
which will explain. No, I don't know whether there's fault or not. Mr. Weiss will explain this in his report.
But we can't, Mr. Hunter Biden walks free on not paying taxes on $1 million from 2014 and 15 because the Department of Justice let it happen, right?
Again, I'm not going to comment on decisions made in a pending investigation. In the end, Mr. Weiss will issue a report. I will provide the report to Congress. You'll be able to question Mr. Weiss as to his reasoning, and he will be able to defend his reasoning.
Would you come with Mr. Weiss when he does that?
I'm not going to know the intricacies of Mr. Weiss' investigation. There would be no point. It's Mr. Weiss who's responsible for this investigation.
But you were head of the Department of Justice.
Yes, and I've appointed him as special counsel so that he can independently investigate this matter.
Okay.
Thank you very much, Senator Kennedy. Senator Manchin.
Thank you, Madam Chairman, and thank you, Judge, for being here. I appreciate your service in so many capacities, very much so. Let me go in a couple of things. This week, the Senate's going to take up a 2-year extension of FISA, okay, Section 702. Some groups have raised concern that House-passed FISA reauthorized would expand the scope of who could be targeted under Section 702 by changing the definition of electronic communication service providers. I, for one, do not have those concerns because we have basically expanded upon how we communicate different ways, and we should be looking at everything, protect our countries. Do you have concerns, or has it been brought to your attention?
Yeah, so I know this particular issue. Let me first state, as I know you know, 702 is essential to our ability to protect the country in many ways, but particularly since the Hamas terrorism attacks on October 7th from foreign terrorism in the United States. The change that you're particularly talking about is a technical change. It's a consequence of internet technology changing in the 15 years since FISA 702 was passed. It's narrowly tailored. It is actually a response to the suggestion from the FISA court to seek this kind of legislative fix. It does not in any way change who can be a target of Section 702.
It's just
That
the way we
remains-
gather, what different mechanisms we gather information from, I guess, right?
Yeah, it can only be, but the target can only be a foreign person
Yeah.
located overseas where there's a reasonable expectation of getting foreign.
So it's not of a
intelligence.
concern that you have basically from.
I
legal-
don't have any concern with this technical
Good.
fix.
I don't either. I just want to make sure you help me
I appreciate it.
confirm that. But I would like to, I'm going to go through a few things that people ask me most.
Of
The
course.
concern of the border is the greatest threat that we face right now. It's been more detrimental to our security, I believe, than anything in modern history that I have seen. First of all, we haven't taken action on Mexico. It seems like we haven't used what tools we have. They're a member of the USMCA, the new NAFTA, if you will. And they haven't been a good partner, let's put it that way. And there's been more people, my state is number one killer, is opiates, illicit drugs coming into. We were targeted and it just devastated our state. Is there anything that can be done in them being violation of USMCA, which could threaten which we would have the ability to threaten their participation, or as a member of USMCA? That would, to me, to be the greatest concern they should have for their economics in their country. And I would think they would respond. Nothing else seems to have worked. And we haven't had the response, basically shutting down fentanyl. We haven't been able to shut down the precursors from China. And that has killed more people in America since the Civil War, is opiates and illicit drugs coming into our country, than all the wars combined. It's unbelievable.
So there is no worse threat this country has faced with respect to drugs than fentanyl. As I said somewhat earlier,
Do we have the powers to use it, USMCA?
so yeah,
against-
this is an interesting tactic I have not thought about. This is something I might ask my staff to talk.
Could we work with you on
Ambassador
this?
Ties?
It would be
yeah.
very helpful if we could. There has to be something to shock them into realization that they have to be either a good neighbor, be part of the USMCA, or basically us declare them not to be a good neighbor or deserve the standing they get. Because there's an awful lot of illicit stuff comes through that border. And also a lot of dumping comes into the border that harms our economy. I'd love to expand that with you. And my final question is concerning the border, sir. I get more questions on that. Does the president have the ability as an executive order to basically declare an emergency there and shut it down? And I know that there's a ruling from Hawaii, which is the U.S. versus Hawaii Supreme Court ruled that he has the broad authority, the president, to suspend admission of migrants. I'm having a hard time. I've been encouraging them every way I possibly can to use the rules and tools that you have and your executive powers to shut this illegal until we get a handle on it, because we're not going to come to an agreement politically here unless we're forced to do it.
So I would say the best solution to this problem is the bipartisan proposal with respect to the border that had been worked out, both as a combination of changes in who can be removed and who can come into the country, as well as the money necessary for Department of Homeland Security to put in X-ray machines that would be able to stop.
Let me put it in a different way. The president has had no problem whatsoever declaring an executive order to basically to relieve or remove student debt. And that's been challenged, and it's been upheld that he can't do it in court, but he does it anyway. I'm fine, and whatever he thinks he has the right to do. I don't know how this is any different to stop illegal and thinking they're going to take us to court and it might be overturned, but at least it sends the message that we are serious about the border.
I know, as has been reported, that the White House is considering a number of options with respect to immigration. I don't want to get into our deliberations with the president, and I don't want to, make a determination about legality before we have in front of us a particular proposal.
Well, I know my time is up. I would love to go further into our USMCA with Mexico. I think there's something we have to do to shock them into realization. You're either going to be a good partner, or you're not going to be a partner at all.
Well, I'll ask my staff to talk to yours and also to bring in Ambassador Ty's staff, because she seems like
Please.
this is within her bailiwick.
Appreciate it very much, sir. Thank you.
Thank you, Senator Manchin. Senator Murkowski.
Thank you, Madam Chair. Mr. Attorney General, welcome. Good to see you again. Thank you for the trip last summer where you had an opportunity to kind of get a little summary on the ground of some of the law enforcement, public safety issues that we face primarily in rural Alaska. I appreciated that Chair Murray had highlighted murdered, missing Indigenous persons. The work that your teams are doing, working with us in Alaska, is very, very important. Also appreciate the keen focus here in this committee and the subcommittee on fentanyl. I wish that I could say we're far enough away that we have escaped, but our smallest of the small rural villages are being targeted because you can sell this poison there for 10 times more in a village like Quinnahock or Togiak than you can in even Anchorage. So we all need to keep leaning in on that. back to the issue of tribal justice. When you were there, we had good conversations. I think that was very important. We've seen some measurable progress on cross-deputization agreements between the state of Alaska and tribes relating to law enforcement. We've got the Not Invisible Commission report recommendations that are giving us a little bit of a template here. But I am a little concerned in terms of the follow-on from your visits insofar as what more we can do to address the public safety issues. We've asked for some updates. We haven't gotten a lot, and I don't want to be in a situation where these villages, whether it's Galena or Huslia or really any place, feel that you came, you saw, and then there hasn't been the follow-on. We've got a lot of work I think we know that we need to do to implement VAWA 2022 and the Alaska Public Safety Pilot. So I would ask that you and your team can provide us with recommendations for improving the funding opportunities for our Alaska Native communities in the short term here. If we can do this within the next 30 days, that would be great if you have legislative proposals. But we want to keep the momentum going. I know that you committed to me. Your teams are working on that. But if there are legislative proposals, again, we want to try to put some of these in the pipeline.
Well, we're very happy to do that. I will say that it was a real eye-opening experience for me, as you told me it would be, to be on the ground there and to see the difficulty of transportation between one village and another, and the difficulty law enforcement has of reaching a village, and the really inexcusable fact that there really isn't sufficient law enforcement in any of the villages. I can give you just one update. I would say as a result of my visit, budget request includes a plus $14 million from FY24 for special tribal criminal jurisdiction. And I would say it's a consequence of what I saw in Alaska.
Well, let's commit to working through some of these specifics going forward. One of the other things that I have heard is as our tribes are looking for federal financial assistance, not only in the public safety space, but in others, they have been directed to entities for technical assistance, but it's technical assistance that is from the lower 48, perhaps maybe not culturally responsive, or geographically relevant to many of the issues that we experience there. So, you know, I appreciate what the department is doing to try to help bolster the capacity of tribes and tribal organizations as they're looking to gain access to some of these grant opportunities. But it's something that I'd like your folks to look at, because this again is a big challenge. If you're talking to somebody who has no idea that we don't have, for instance, reservations in Alaska, and the construct of the governance just makes it that much more challenging. So I raise that to you. I want to comment very quickly on what Chair Murray had raised about the Crime Victims Fund. You outlined the benefits of it, but I will tell you, I am very, very concerned that we're going to be in a situation where if additional fines, fees, penalties from other sources aren't redirected to address the shortfalls, so many of these organizations that just are working so hard, they're burning out, they can't deal with this year-to-year challenge because they simply don't have the resources. And it's not only in the Crime Victims Fund, it's the impact that we're seeing with our child advocacy centers. Many of our COCs have been using additional funding for their base operational costs in addition to VOCA cuts. So you've got VOCA funds that are being cut, you've got the CACs that are hanging out there. It is really a tenuous situation. I know you know that, but we really need to to have identified some kind of an offset for this 7.3 billion that's proposed to replenish the crime.
There
victims
is a
fund.
proposal. If I have time to respond now, I will. I totally agree with you. This trying to depend on the amount of money we're able to get in any particular year is always going to be uncertain. The administration's proposal in the budget, I don't think there's legislative text yet, would take effect in 2026, provide $7.3 billion in mandatory appropriations over 5 years to replenish and stabilize the fund. I think that's better than the way we're doing it now, year to year. And so our staff would be happy to speak with the staff of the subcommittee and your own staff as well on this proposal.
Thank you. Thank you, Madam Chair.
Thank you, Senator Murkowski. I understand, General Garland, that you're okay to keep going.
Sure.
We don't need a break, so let me ask Senator Peters to go next.
Well, thank you, Madam Chair. Attorney General Garland, thank you for continuing to plow through, and certainly it's good to see you here today with us. Following the October 7 attacks and the conflict between Israel and Hamas, and as that continues, we're seeing significant increase in anti-Semitism, anti-Muslim, and anti-Arab hate. And I certainly worry a great deal, as I know you do, about the increase in hate against these communities all across the United States, including schools. We're seeing it on college campuses. I've heard from Muslim and Jewish constituents who are worried for the safety for their families and their houses of worship. According to recent reports, the rates of anti-Semitism and anti-Muslim hate have hit historic highs in our country. And Attorney General Garland, I know you have said repeatedly that the Justice Department has absolutely no tolerance for violence or unlawful threats of violence fueled by anti-Semitism or Islamophobia, and that no person and no community in this country should have to live in fear of hate-related violence. So my question for you is, given this profoundly concerning trend, can you speak to how the department utilizes your existing resources, whether via Civil Rights Division or elsewhere, to support these communities that are being impacted? And in what ways does the department need additional support to respond, given the large increase of this type of violence around the country?
Yes. I couldn't have said it better than you did with respect to the level of our concern. Since the Hamas attacks on October 7th, spiking hate crimes, both against, with respect to Islamophobia and with respect to anti-Semitism, just gone through the roof. We have brought quite a number of prosecutions even during that time since October 7th. And we treat this in the most serious way. We have to disrupt and deter such acts. And the only way in the end to do that is to get heavy sentences. With respect to our work in this, this is a combination of the work from our Civil Rights Division side and from our where it becomes domestic violent extremism to our national security side. We've asked for $201.3 million, which is a 10.8% increase for the Civil Rights Division, 14 attorneys, much of that to cover hate crime investigations, which are spiking. The FBI Civil Rights section has asked for $114.5 million, which is an increase in 30% for that purpose. In the U.S. Attorney's offices, we've asked for $55.8 million, an increase of 12.2% for the civil rights coordinators to work on these kind of matters. An important but little known part of the department is our Community Relations Service, which tries to mediate conflicts so that they don't get to the stage that we're talking about here. And for them, we're asking for $29.1 million, which is a 21.2% increase. That's on the civil rights side. We have another whole set of requests on the national security side where this moves from hate crimes to what we would regard as domestic terrorism.
All right, well, good, and it's important to keep that focus, and I appreciate your focus on that and your request. In 2018, I led the successful bipartisan effort to authorize a new grant program titled the Emergency and Transitional Pet Shelter and Housing Assistance Grant Program. This program was set up as a pass-through, which funds initially going to the USDA but the grants are administered by the Department of Justice, and it provides emergency and transition shelter options for domestic violence survivors with companion animals. And this is actually very critical, given that studies have shown that victims of abuse are less likely to leave a very abusive situation if they have a beloved pet. Abusers often target that pet. And in fact, a number of studies have shown that on average, the person who is being abused, the survivor, will delay leaving a relationship for up to 2 years, 2 years being in that, because clearly they care about this pet who's going to be the target of further abuse. So this vital program helps the federal government ensure that more domestic violence shelters can accommodate victims with pets, or they arrange a third party to make sure that the victim knows that that pet will be secure. And in the years since its launch, we have seen demand far outstretch the available funding. And in fiscal year 24, I secured authorized funding of $3 million for the program. So my question for you, Attorney General Garland, do you agree that it's essential that we continue funding a grant program authorized by my PAWS Act and help empower victims of domestic violence with the tools they need to escape the violent situations that they're in?
We have to protect the victims of domestic violence, and thanks to the PAWS Act, over the last 3 years, our Office of Victims of Crime has made 31 awards totaling $8.8 million for the nonprofit entities that support domestic violence survivors and their pets as they navigate into transitional housing.
Great. Well, I appreciate your support of the program and your statement on the necessity of doing this to help our survivors. Thank you. Thank you, Madam Chair.
Thank you, Senator Peters. Senator Moran.
Chairwoman, thank you again. General, let me raise 3 things in pretty, I hope, short order. We've talked, I think, since the beginning of my time at CJS and your arrival as Attorney General about my desire to focus law enforcement grants. There's lots of opportunities for local law enforcement to compete for grants to support local law enforcement, but we've highlighted numerous times to you and to your predecessor about the challenges that small law enforcement agencies in small communities have. They don't have a grant writer. It takes a police officer off the street or a sheriff's officer off the roadway to apply for grants. And we have encouraged the department to create a separate grant program specifically for small communities. I just would like to ask you if you, I doubt that you have with you, but would you see if there's any statistics that indicate how we're faring in getting small law enforcement agencies across the country additional resources as compared to others or compared to the past?
Yeah, I'll be happy to go back and ask how those statistics compare. Problem you pointed out has been pointed out to me by local sheriffs, by local police departments in small rural areas. It is a problem because they don't have grant writers. They don't have they may not even know about the availability. So we have our Office of Justice programs and our COPS office have gone to great lengths to try to simplify the applications, to reach out to rural law enforcement about the possibility of getting grants and helping and assisting in the applications. But I don't know the statistics, and I will get back to you.
We'd like to see if it's working. I had suggested, and I don't know whether the suggestion, and this predates you at the department, but that there be created a separate grant application and program for those small agencies. Let me also highlight anti-Semitism and hate crimes. And you have focused your attention on this issue, and I appreciate that. But according to data tabulated by the Anti-Defamation League, there were 5,204 incidents between October 7th and the end of 2023. That's a number that is greater than the entire total of those instances in 2022. I commend you for your recognition of this issue and efforts. And is there things that you would point to, specific proposals in the department's budget request that would be evidence of attention to anti-Semitism and hate crimes?
Well, you're absolutely right about that. I spoke at the Anti-Defamation League conference earlier this year and recited the statistics that the FBI has, which are very much consistent with the statistics that ADL itself is reporting. The parts of our budget that are relevant here and are most important are the increases for the Civil Rights Division, which has particular jurisdiction over hate crime prosecutions, the FBI's Civil Rights Section, which supports those prosecutions, and our National Security Division and U.S. Attorney's offices that bring these cases. U.S. Attorney's offices bring the hate crime cases, but then also bring along with the National Security Division where hate crimes progress even further across the board into domestic terrorism.
Finally, General, I would mention an occurrence in Kansas. The United States Penitentiary in Leavenworth went into lockdown and then modified its operations beginning March the 1st, now more than a month ago. There are security situations in the BOP facility, I know, that can require certain actions to protect the safety of inmates as well as the staff. But these status changes are inherently disruptive. And of course, we need to remember that inmates are entitled to civil rights and that the BOP staff are entitled to a functioning environment. My understanding is this issue, this circumstance is close to being resolved if it hasn't already been today. But I wanted to make sure it was a priority for you and the department.
Yes, I'm not specifically familiar with the situation in Leavenworth, but I will ask my staff to get back to yours today.
Thank you. I just really wanted to bring it to your attention. Thank you.
Thank you, Senator Moran. Senator Reed.
Welcome, General. Last summer, the Senate Banking Committee passed the Safer Banking Act. It's a bipartisan legislation designed to help state-approved marijuana businesses access banking services. Section 10 of the original legislation would have compromised law enforcement and national security by requiring banks to notify customers when the government requested termination of an account. In essence, the original language meant that serious criminals could be tipped off that they are under investigation. That includes fentanyl distributors, gun runners, mob bosses, etc. Fortunately, through a bipartisan committee process, we worked to address major flaws in Section 10 and curb its negative effects. Do you agree that such a policy would handcuff law enforcement and the intelligence community if the bank had to disclose that their account has been terminated by law enforcement?
I have to say I'm not familiar with the provisions of, I know what the act is and the proposal. I'm not familiar with the requirements in general. As a theoretical matter, without commenting on that, obviously, if we are investigating someone and that person is advised of our investigation, that makes our investigation all the more difficult and may compromise it. But I can't answer specifically with respect to the statute.
Let me prepare a letter, send it to your office so that you and your staff can review it and then respond. I know when you come up here, it's sort of a range of issues from all the way across the board. So I completely understand that. A quick other question, and again, this might not, I think you would be familiar with this. The reauthorization of FISA, there was a great debate in the House about a warrant requirement. Would you support a warrant requirement for U.S. persons? It's 702.
So 702 is absolutely essential to our ability to protect the country from everything from nation states to foreign terrorist-inspired attacks in the United States. I don't support a warrant requirement. We are talking about information that has already been lawfully collected pursuant to a court order because the target is a foreign individual operating abroad where foreign intelligence information is likely. And courts have never required us to search lawfully collected holdings with a warrant. So I don't think it's constitutionally required. I am concerned about errors in the query system that occurred. And when I first came in, these were reported to me. And I directed the Deputy Attorney General and the FBI Director to quite a number of fixes in to prevent that problem. And the consequence has been a really large decrease in the number of queries that are made in excess of 90%, and a compliance rate in the area of 98%. The problem with a warrant is that a warrant requires probable cause of something, and we don't have probable cause at the stage of the query. Query is intended to find out what's in our holdings so we can determine whether we have a probable cause. If you impose a warrant requirement with the probable cause requirement, it effectively makes queries impossible to go forward. So it would just eliminate our ability to use 702 to find out what information we have with respect to foreign terrorism, with respect to cyber attacks, with respect to foreign intelligence collection by our adversaries.
Mr. Secretary, excuse me, Attorney General, as you understand, because it lapses,
Yes.
are you comfortable with the House version of the legislation?
Not knowing exactly what the House version is, I'm comfortable with the provisions that provide for the fixes that we have administratively put into place, and that do not require, though, a warrant requirement.
Thank you very much. Thank you, Madam Chairman.
Thank you, Senator Reed. Senator Fisher.
Thank you, Madam Chair. Welcome, Mr. Attorney General. It is good that you're here, and I appreciate that you're here. Thank you. I noticed that President Biden's budget request for the Justice Department states that its goal is to uphold the rule of law. I appreciate this goal, but I don't see a budget that truly supports this vision. I see cuts to resources for local law enforcement who are struggling right now. I see the elimination of a program that helps put criminal, illegal aliens in jail. And I'm seeing cuts like these in favor of more spending to fulfill President Biden's political goals. Smart and responsible budget cuts are important, but if you really want to uphold the law, cuts to law enforcement programs aren't the right place to start. For example, your funding request for the Community-Based Violence Intervention and Prevention Initiative is $110 million more than the funding you're seeking for the Regional Information Sharing Systems Program, known as RISC. RISC is a proven communications program that helps state and local law enforcement combat criminal activity. As nice as community intervention programs are, they'll never replace the men and women in uniform who hold the thin blue line every single day. The president's request actually tries to cut funding for the RISC program by several $1 million. Did the department assess a reduced need for RISC funding for FY25? Because that's not what I'm hearing from Nebraska sheriffs.
I have to say that funding for state and local police is a high priority for the Justice Department. We're asking for more than $4.3 billion in funding for state and local police, and $16.5 billion in a mandatory program over 5 years. We're asking for an increase in our cops hiring program of 893.5%, $2.5 billion total, $2.3 billion increase. That money goes for state and local police hiring. We're asking for $524.5 million for burden JAG grants, $323 million, a $7.5 million increase for our Office of Violence Against Women grants, which focus on local law enforcement and prosecutors. We've asked for $133 million for our public safety officers benefit program.
I know, excuse me, I have limited time, but I know there are a number of programs out there, but specifically to the RISC program, which is a program that really offers secure information sharing and communications capabilities, investigative support services, and that all enhances our officer safety. And so what I'm hearing is the priority for that program, which we're looking at a $4 million decrease, and the president's requesting 40 million. You compare that to the community-based violence intervention prevention initiative, that has increased a top line to 250 million over 5 years. So why we're looking at in the FY24 budget, $0 for that program, we're now looking at at 150 million increase in that program. So I'm just curious, if you reach out to local law enforcement, which I know you do, but do you hear a priority being for the RISK program as well?
I'm sorry and maybe even embarrassed to say that I'm not sufficiently familiar with the RISK program. I have spoken constantly. We meet quarterly with state and local law enforcement, and I've gone to more than 40 U.S. attorneys' offices to meet with state and local. This issue hasn't been raised for me, but I will ask my staff to get back to you. Many of the things you're talking about sound like things that are also covered by the other grant programs, but
You know, we also face issues because of the chaos that we see at our southern border. There's a program that you have there. It's one of the few programs that help states with that. It's the State Criminal Alien Assistance Program, which the president has proposed to cut funding to that entirely. Reason being that it's a duplicative program. My time is out, but I'd like to submit a couple more questions to you if you could respond to it. And specifically that program, because we are seeing across this country, cities, states, seeing increased needs for these assistance programs because of the chaos that we see at our border, and to find one that, again, is working for my state, and to see that being cut, I'd like to explore the answers that you provide for that.
I'll be happy to answer the question.
Thank you, sir, very much.
Thank you, Senator Fisher.
Madam
Senator,
Chair, if I could,
yes.
I realize I confused my answer to the senator's question about the House bill for 702, because there have been
Please
quite a
clarify.
number of House bills. The one that passed the House is the one that we do very strongly support. It's the one that passed last week, and I do urge the Senate to pass that bill.
Well, thank you for that clarification. Senator Coons.
Thank you, Chair Shaheen. Thank you so much, Attorney General Garland. Senator Fisher and I may find some things to work on out of her questioning. We are the co-sponsors of the Recruit and Retain bill that has already passed the Senate and would strengthen the COPS program's ability to help state and local law enforcement with recruitment and retention. As the co-chair of the Law Enforcement Caucus on the Judiciary Committee with Senator Cornyn, and someone who spent a decade in local government responsible for the second largest police department in our state, I've focused in my 14 years here on partnerships like RISK, like information sharing and ways to support local law enforcement. As you said in your opening testimony, the investments, the initiatives that you've taken in the Department of Justice and the brave men and women who serve us every day through DOJ are having an impact. In my hometown of Wilmington, murder is at a 20-year low. The broad perception of crime is not improving at the rate we would hope, but the reality, in my hometown, we had a crisis of shootings and murders that lasted for a decade. We are now seeing a persistent, sustained, significant drop in violent crime, and I thank you for your leadership on that. The American Rescue Plan was the single largest investment in law enforcement and public safety by the federal government in our history, and I'm pleased your request builds on that success. I wanted to reference 4 different things briefly in my questioning. The Victims of Child Abuse Act and the critical work you're doing to help fund and implement that, boosting hiring through the COPS program, as I referenced, protecting those charged with upholding the law, our judges at the both federal and local level, and enforcing IP rights. I also think it's key that we continue funding the implementation of the Bipartisan Safer Communities Act, a critical gun safety measure that passed by a broad bipartisan margin here in the Senate. I worked hard with Senator Blunt to reauthorize the Victims of Child Abuse Act programs And I appreciate the department's effort to increase by 7% of the funding for this. It is a critical, children's advocacy centers are a critical resource to ensure that law enforcement, mental health professionals, medical professionals come together to work on child abuse investigations in a child-centered way that is effective. And I'm proud of the work Representative Krista Griffith and her team at the Children's Advocacy Center of Delaware have done. I used a CDS to strengthen that. The need is great. There are a significant number of unserved children. Can you explain why the Children's Advocacy Center program is important and what role it plays in helping solve crimes?
I have to say, I'm not intimately familiar with the center. Obviously, we need children's advocates when children are victims. They can't advocate for themselves. They need.
Mr. Attorney General, I'll interrupt. I would be happy to familiarize you with the investigatory tool that it is.
Great.
It's a unique model. Its name is somewhat misleading, but I've seen it work on the ground in our community. I appreciate your commitment to law enforcement hiring and funding new positions. How are you working to ensure that small departments can fully access the COPS program? The agency I was responsible for was the second largest in our state, but frankly, COPS programs have made a real impact in smaller agencies.
The director of the program is very sensitive to the concerns of the small agencies, both in urban areas and in rural areas, understanding that they don't have the luxury of having administrative officers who can fill out the forms, and do the appropriate collection of data, nor even necessarily interrelate with respect to the internet programs. So they have developed reach out programs. They've simplified the applications, and we've tried to make known in our quarterly meetings with all the law enforcement agencies, organizations, the availability of these reach out services.
We had a Judiciary Committee hearing on this last week, and Director Clements, I urged him to try and strike the right balance between ensuring appropriate oversight and auditing and performance standards, but minimizing needless and duplicative paperwork. The Supreme Court Police Parity Act, something that I helped get into law, I think signals the seriousness with which I take the security of our federal judges. Also, frankly, the vast majority of judicial officers are at the state and local level, and Senator Cornyn and I have introduced a bill to create a state judicial threat intelligence and resource center housed at the State Justice Institute. Is the department tracking an uptick in violent threats against federal judges? And what do you think Congress and the department can do to help secure the safety of our judiciary at the state and federal level?
Yes, we are, and that's reflected in prosecutions that we're bringing. It used to be extraordinarily unusual to have those kind of cases, and now we're fielding more and more quite serious threats, finding those people and prosecuting them. I say the principal way that can be of assistance is the appropriations for the Marshal Service. Which has in particular an item for increasing $28.1 million for judicial security. The Marshal Services, the ones who provide judicial security for all the more than 2,000 federal judges across the country.
Thank you. And frankly, while not as urgent as police hiring, reducing violent crime, protecting our judges, I continue to be gravely concerned about intellectual property theft by China. You have a small but effective program that helps with the training and implementation of IP theft programs. I recommend to you sustaining it, if not growing it. Thank you, Madam Chair.
Thank you, Senator Coons. Senator Capito.
Thank you, Madam Chair, and thank you, Mr. Attorney General, for being here today. I just wanted to put something on your radar screen that struck me when I listened to Senator Moran's question about Leavenworth. We wrote a letter to you, a bipartisan letter, Senator Manchin and I. We have quite a few employees at the Hazelden prison that has over 3,000 inmates. A whistleblower came forward with pretty graphic details of mismanagement, abuse, and worse. And it's a chronic problem there because I think lack of workforce and lack of ability to staff up properly. I don't know if you have any reaction to what's going on at Hazelden specifically, or do I need to follow up with you?
We'll follow up, but this has come to our attention, obviously, not only from your letter, and I believe the actions were taken over the last couple of weeks, but we'll get more information to you. I think you're right on the problem of recruitment. It's a difficult, it's not only Hazelton where it's difficult for us to recruit correctional officers. It's a very dangerous job in facilities that have, there's not been the capital investment over the last decades that's required. And sometimes state and local facilities not too far away are offering more money in terms of salary. So we have asked for money for retention and hiring more than the normal salary that we would otherwise be able to pay. That's what the director thinks is going to be necessary to recruit the number of officers necessary to provide safety in our prisons.
Right. I think safety is the issue. Obviously, it has been at that facility. I know you've answered a lot of questions on fentanyl, but this is a huge issue for West Virginia. We have the most really drug-related deaths per capita than any other state, and most of it's tied to fentanyl. Do you think that the $2.7 billion is an adequate budget for the DEA, and how could our resources be better prioritized to reduce and one day eliminate the amount of deaths we experience from fentanyl? Obviously, to stop the flow of fentanyl would be number one, but how would you respond to that?
We would always like more money, but we're obviously trying to live within the caps that were agreed to. I think the budget that we've asked for is a 6% increase over the enacted for 24. Includes a addition of 40 agents, which will be very helpful. This also includes money for diversion control, which was part of the problem in quite a number of states with respect to opioids. And then there's the money that we have available in grants with respect to, for, of course, state and local opioid addiction treatment and protection. So that's the more than $490 million in counter drug-related OJP grants, including the CARA grants and the COSOP grants.
You know, we took a trip to Mexico, met with the president of Mexico. Senator Moran was on that trip just briefly. And he was on the trip the whole time. It was a brief trip. Anyway, we sat in and listened to the president of Mexico basically tell us that you have a demand problem in the United States. And you've heard him say this publicly. And that because we were imploring him to stop the flow of the chemicals that are coming in from China and then having the development and production in Mexico and then flowing into the United States. What is the current state of that disruptive or that needed disruption between the Mexican border and the United States in terms of getting the Mexican government to cooperate with our government law enforcement to be able to shut these things down?
Senator, I've sat through that same discussion 3 times by the president of Mexico, so I'm familiar with your frustration. I would say cooperation is improving, but much, much more is required. They have increased the number of precursor chemicals on the list that have to be registered to come in. They have, at our request, extradited a number of the people who we've indicted to the heads of the Sinaloa cartel, the Chapitos, the sons of El Chapo. They have destroyed labs. And I will say, in connection, for example, with their arrest of Ovidio, the son of El Chapo, a number of their Mexican Marines lost their lives. They are facing an organization which in many ways has more heavy weaponry than some small countries. So it's dangerous for them, but it is not sufficient. And that's why I keep going. That's why my Deputy Attorney General keeps going. And that's why our law enforcement agencies at all the operational level keep going to try to get more cooperation.
Thank you. Thank you for coming.
Thank you, Senator Capito. Senator Britt.
Excellent. Thank you, Madam Chairwoman. Mr. General, thank you for being here today. Really appreciate it. During last year's hearing, I asked you about training materials that were used to prepare the U.S. Marshals assigned to protective details at the homes of our Supreme Court justices in the aftermath of the leaked Dobbs decision. Those training materials made it clear that far from having the full authority to arrest people under any federal statute, as been previously testified, the marshals on the ground at the homes of the justices were actively discouraged from making arrests under 18 U.S.C. 15, Section 1507. As we discussed last year, Section 1507 makes it a crime to picket or parade near a residence occupied by a judge with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, as I know that you are fully aware. In the aftermath of that hearing, I and several of my colleagues sent a letter to you on May 3rd, 2023. That letter recounted the contents of some of the training materials discussed during the hearing and also discussed new materials that we had received afterwards. Those new materials consisted of several different versions of post orders that were provided to U.S. Marshals assigned to protect the homes of the justices and further confirmed that they had been actively dissuaded from making arrest under Section 1507. The letter asked for a response to 19 different questions and/or document requests by May 24th, 2023. To date, almost a year after it was transmitted to DOJ, I have yet to receive any response to that letter. My staff repeatedly reached out to DOJ to inquire about the status of the response, including via email on May 26th, June 13th, and July 11th, and by phone on numerous other occasions. Staff for this subcommittee actually got involved and also reached out to DOJ's Appropriation Liaison Office in August to inquire about the status of the response to my letter. Neither my staff nor the staff of this subcommittee, to my knowledge, have received any type of update regarding the timeline provided for a response or an answer to any of the questions that were in that document. And so my question to you is there is a reason that I didn't get a response to that letter, and will you commit to me to getting one before the end of the week?
I'll speak to my staff about the responses to your letter, but as you no doubt know, the director of the Marshal Service testified extensively February of this year on the precise questions that you're asking. He was subject to further questioning, and he explained. He confirmed that what I testified to before this committee was correct and accurate and true, that he testified that I had directed him that his first priority is to protect the lives and safety of the justices and their children, and that they have full authority to make arrests under any other statute, including Section 1507, but that they
Mr. General,
that they do not do so in a way that would risk the lives. With respect to someone standing post who sees a—
yes, sir. Well, Mr. General, my question is really about the letter. I mean, yes,
I'm
sir.
trying to answer you. There was a testimony in person.
Right. Well,
by
then that
the-
would have been, sir, if I may, then that would have been an easy thing. You're now recounting all of the things that you could have put in a letter. I'm actually a member of the United States Senate. I may sit on an opposite side of the aisle. I may be from a state that doesn't maybe come to your radar. There may be some other reason, but I actually deserve an answer. And so I would respect that you respect that. And even if that answer is not something I like, over a year with no response after we're trying to get one, and you could have very easily sent a letter that pointed to those things right there. It's disrespectful, and I really don't appreciate it.
I have the greatest respect.
So in the future, though, too, and as a former staffer myself, I would assume that somebody sitting behind you knows that you didn't respond to me. And I just want to say, I deserve your respect, and I would hope that you would give it to me in the future. And so even if it's what you just said right here, I'd like a letter by the end of the week.
I greatly respect you, Senator. I greatly respect the Senate.
Well, thank you.
I guess I'd assume that.
Then we will get it. Then you can put that in, you can put that in a letter. Yes, sir.
Transcript of the testimony gets to you in a letter, yes.
Thank you. I appreciate it. Given that, I actually have a similar concern as as Senator Coons, just about our federal judiciary. And when I look at what is happening across the country, I just want a commitment from you that DOJ and Marshal Services will enforce all applicable laws, all of them, including obviously 1507, to protect federal judges, and that, as he said, that we're doing everything that we can. And if there's anything that we need to be doing more of, that we can communicate on that, and certainly look forward to partnering on making sure that we're doing it.
As a longtime federal judge who cares very much about the safety and security of my former colleagues, I have done way more than any attorney general in history has done in this respect, and I can promise you that I will continue to do so.
Excellent. And looks like I am out of time. Thank you.
Thank you, Senator Britt. Senator Van Hollen.
Thank you, Madam Chairman. Mr. Attorney General, great to see you today. And I do want to start by thanking the President and the Biden administration for all their help and rapid help in response to the bridge collapse in Baltimore. There are many pieces we need to pull together, but the FBI they were among the first on the scene to try to rule out foul play, terrorism, and they've been continuing to be present. So thank you and the Justice Department. The state of Maryland has now been enrolled in what's called the Emergency Repair Program. It's a program at the DOT, and we're really glad to be part of it. Senator Cardin and I have introduced legislation to ensure that the President's pledge that we as a federal government will come together and make sure that we cover the costs of the bridge replacement are met. But we also are writing into that legislation a clear directive that any funds recouped as a result of lawsuits or the liability will be returned to the federal taxpayer. That reinforces a provision already in law. I just want to ask you and the department for your commitment to work with us to make sure that if there has been malfeasance, negligence, that federal taxpayers will recoup expenses that they're putting out for bridge replacement.
Yeah, we'll of course use every tool we have with respect to recovering from any wrongdoers if we find the kind of wrongdoing that allows us to make those recoveries.
And as I understand it, whether the suits are brought by the federal government or by states attorney generals, the federal government has the first priority claim on any monies that come in as a result of that. Let me also thank you and the President for the regulations, guidelines that you put forward in response to the Safer Communities Act, specifically work to close the gun show loophole. So I chair the appropriations subcommittee that oversees the FCC. One of the issues that they try to track and prevent are robocalls, which I think every American has been the victim of robocalls. And I want to congratulate the department, DOJ. I think in 2021, there was a major recovery of about $10 million from one of these operators who was violating the various federal laws. But in testimony by the chair of the FCC, Chair Rosenworcel, she has asked for authority for the FCC to directly bring these cases, because as you can imagine, there are lots of robocall cases. Understandably, not all of them, rise to the level where DOJ would use its assets to prosecute, but the FCC doesn't have the authority to prosecute. They can impose a penalty, but they can't enforce it. So my question to you is, does the DOJ have any opposition to Congress empowering the FCC to bring these cases directly in court and enforce them?
Right. So I haven't thought about that specifically, so I have to get back to you. As a general matter, it's proven to be an element of good government to have all of the litigation in the hands of the Justice Department, overseen by the Attorney General, with respect to all of civil and criminal enforcement, and make sure that the United States is always taking the same position in different cases. These cases involve not just a specific question under a statute, but many other civil procedure kinds of questions. So I'd say as a general matter, the department favors the litigation remain in the hands of the department. I have not heard of any problems from the FCC with respect to us not moving vigorously or aggressively enough on those cases, but I will get back to you.
Well, Mr. Attorney General, I'm happy to share with you the testimony of
Yeah.
the chair. And again, she wasn't being accusatory with respect to DOJ, but I think it's a fact that, given all the cases that you're facing, you don't have the time and the resources to commit to many of the robocall cases. My understanding is the FTC has some authority to bring cases directly.
Some, yeah.
Right. So I hope you would agree that we can provide the FCC some limited authority to bring cases that the DOJ that are pending to correct. I mean, there are lots of penalties that are not collected. Right. So it's not a hit on DOJ, but it's a question of making sure that we enforce federal law.
I'll look into those circumstances and I'll ask my staff to talk to yours.
Thanks. So one other question. I know the FISA legislation has come up. I heard your response to that. Many of us believe that at the FISA court, there should be even more of an opportunity for the sort of people's advocate to weigh in these cases. There is a process, as you well know, to file amici briefs, but there's legislation that Senator Durbin, I think Senator Wyden have proposed, where one element of that would be to require the court to appoint amici in certain narrow cases involving Americans' First Amendment rights, cases involving the investigation of religious figures, members of the media, cases involving new technologies or new surveillance programs. Would you object to ensuring that an amici is appointed in those kind of circumstances?
So I tell you, this is separate from the 702 legislation that you're talking about. This would be separate legislation.
I think this this would be relates to all the FISA legislation, including the section 702. This goes beyond 702. I'm not talking
part
about
of the reauthorization.
Yes.
This is not part of that.
This is part of the reauthorization of
702.
I think that's where they're proposing to
I
include.
see. So we strongly support the bill that passed out of the House as it is. We need this finished by the end of the week or our authorization expires. So anything that would get in the way of that happening, I'm reluctant to tell you, but I have to, that I couldn't support. I think the judges know well when they need amicus, and they have the ability to appoint amicus. From my own experience during the time I was in the same courthouse with the FISA judges, they are very pleased with the amicus that they have, and they know well when difficult cases arise, how to appoint one and to appoint one. There's nothing that prevents them from doing that now.
No, I appreciate that, Madam Chair. I'll just end by saying, in a typical, adversarial proceeding, there's a representative there for, the adversary. Here, the question is just whether to make sure that the people who may be, on the receiving end of the investigation have their rights protected. But we can continue that conversation. I will say there's quite a bit of concern about this provision that came up today that was added in the House passed bill that was not part of the Warner-Rubio bill, but I'm sure that'll be a subject of conversation in the coming days.
I'm sure it will. Thank you,
Thank you.
Senator Van Hollen. Mr. Attorney General, I understand you have a hard out at 11:30. I would like to just raise two brief points before we close the hearing. In March of 23, you testified in front of the committee, and we discussed anomalous health incidents. I relayed the situation of someone I had met on a congressional delegation visit to the country of Georgia. She was the wife of a career employee with the Department of Justice, and her life and career had been upended because she had been affected by an anomalous health incident, and she had not been able to get satisfaction from the Department of Justice for that. You talked about taking a look at that and coming up with a rule that could be implemented. Can you tell me when that draft rule is expected to go into effect?
I can tell you, I signed the rule. I believe it's in with the Federal Register now, and as soon as they publish, we'll be able to reach out and start processing these claims. I'm grateful for you bringing that to my attention.
Well, thank you, and I'm delighted to hear that that is progressing, and hopefully we can ensure that people who have been affected get some satisfaction and some help for what's happened to them. The other issue is one that you raised earlier in the questions from Senator Moran and Senator Capito about recruitment and retention of our federal corrections officers. FCI Berlin, which is a prison in northern New Hampshire, has had similar recruitment issues. It's a very rural part of our state, far away from lots of urban areas. And while lots of people really like that, it makes it hard to recruit. Further, a number of officers have been called down to facilities in New York, which have even more extreme challenges with hiring, and have been asked to go serve there for a period of time, which creates more concern and pressure in Berlin. We are also considered in the Boston metropolitan area, which means that the issue you raised about people being able to get more pay in other areas is exacerbated, because even
Okay, the subcommittee on oversight will come to order. Without objection, the chair may declare a recess at any time. Also, without objection, the meeting record will remain open for 5 legislative days, so members may submit any materials they wish to be included therein. Thank you, Ranking Member Torres, members of the subcommittee, and our courageous whistleblowers for joining us for today's oversight hearing. These whistleblowers are coming forward today to share for the first time under oath their firsthand account related to National Guard deployment on January 6th. None of today's whistleblowers were interviewed under oath by the Department of Defense Inspector General or the Select Committee. January 6, 2021 highlighted a culmination of failures at many levels. For today's hearing, we're examining the Department of Defense and the DC National Guard's response to the violent breach of the Capitol. So we'll get into it. I'd like to play a brief video about the time frame of the delay.
Is this the video we received just this morning? Last night, okay.
I want to thank the minority for their indulgence in playing the video. I think it's important to kind of set the stage of just how important 3 hours and 19 minutes can be on a day like that. At a previous hearing, we heard testimony from former U.S. Capitol Police Chief Stephen Sund about the former Speaker and the congressional leadership delay of the U.S. Capitol Police's request for assistance. On January 6, 2021 at 1:49 p.m., the DC National Guard received the first request for immediate assistance from the U.S. Capitol Police as protesters started to gather and force their way into the Capitol complex. However, at this time, the Capitol Police Board had not officially approved the request. At roughly 2:12 p.m., protesters breached the Capitol and began assaulting police officers. Staffers and members of Congress were ordered to evacuate, including myself and others that are here today. Capitol Police attempted to secure members and clear the Capitol, but were quickly outnumbered. There have been many testimonies of that day, but one thing is clear. The U.S. Capitol Police requested and needed urgent assistance from anyone who would answer the call, including the Metropolitan Police Department and various federal law enforcement entities and the D.C. National Guard. However, there was a delay deploying the National Guard for over 3 hours. Almost an hour after the Capitol was breached at 3:04 p.m., the Acting Secretary of Defense, Christopher Miller, approved the D.C. National Guard to deploy to the Capitol. Just a brief history lesson for those who do not know. Executive Order 11485 delegates oversight of the D.C. National Guard to the Department of Defense. A 1969 memo further designates this authority specifically to the Secretary of Army. On January 6, 2021, the Commanding General of the D.C. National Guard, William Walker, reported directly to the Secretary of the Army, Ryan McCarthy. The D.C. National Guard was at the Armory, 1.2 miles away from the Capitol, waiting for authorization to deploy to assist civil authorities and quell the riot. However, the D.C. National Guard didn't arrive at the Capitol until almost 6 p.m. That's 3 hours and 19 minutes of delay. During those hours, chaos engulfed members of Congress, law enforcement officers, reporters, staffers, and citizens. During those hours, necessary help from the D.C. National Guard was not on the way. Our goal today is to get to the bottom as to why. It took too long for the D.C. National Guard to arrive at the Capitol. The 113th Wing Capitol Guardians have a proud history of protecting our nation's Capitol and serving our nation's leadership. Nevertheless, the New Jersey State Police from nearly 150 miles away responded to the Capitol before the D.C. National Guard. Additionally, the Pentagon knew that there was a threat to governmental operations because by 3:37 p.m., the Pentagon sent its own security forces to guard the homes of defense leaders. At 3:37 p.m., no D.C. National Guard forces were on the way to the Capitol. Throughout my subcommittee's extensive investigation into the events of January 6 and the Select Committee on January 6, we have uncovered concerning inconsistencies regarding the mobilization of the D.C. National Guard. Through phone records, firsthand accounts, sworn testimonies, and after-action reports we have gathered, there appears to have been a significant delay at the Department of Defense in either deploying the National Guard or communicating the order of deployment. Either way, the purpose of this hearing is to hear the D.C. National Guard story for the first time ever about the 3-hour and 19-minute delay. On November 16, 2021, the Department of Defense Inspector General released a report reviewing their role in the response to January 6, which claimed that the D.C. National Guard was deployed to the Capitol as quickly as possible. However, the report also credited significant delays in deployment to D.C. National Guard Commanding General Major General William Walker, neglecting to mobilize after receiving orders. Specifically, the DOD report concludes that the leader of the National Guard response, Major General Walker, received direction from the Secretary of the Army, Ryan McCarthy, to deploy the D.C. National Guard to the Capitol twice, once at 4:35 p.m. and again at 5 p.m. Major General Walker denies that either of these calls took place. Despite the many inconsistencies and contradictions of the Department of Defense's responsibility that day, the Select Committee on January 6 ignored these discrepancies despite them being shared privately by their own staff and barreled forward with the DOD's side of the story. Following the release of the DOD report, multiple whistleblowers from the D.C. National Guard who were present with Major General Walker have come forward to share their experiences. According to their testimony, hours of vital response time were missed because senior Army officials had personal concerns regarding military presence at the U.S. Capitol. Today, we have the responsibility of recognizing these D.C. National Guardsmen, listening to their testimony, and honoring their patriotism. These brave men who showed up to defend the Capitol and were discarded and ignored when they tried to come forward. I reached out to the DOD regarding concerns with their report and contradictory narratives. For nearly 2 months, I have not received any answers. Today, we will learn more about what happened that day regarding the delay. We'll hear a side of the story that has been ignored for too long. Most importantly, today, we will look into the future and make sure that our Capitol Guardians, and our law enforcement partners are more prepared today than they were 3 years ago. We're only able to conduct this oversight because whistleblowers have come forward to share their stories. I encourage anyone to reach out to the subcommittee as our investigation continues. I now recognize the Ranking Member, Ms. Torres, for 5 minutes for the purpose of providing an opening statement.
Thank you, Chairman, and thank you to our witnesses for being here today and for your service to our nation, particularly on January 6th. You sacrificed your time to protect us, and we owe you a debt of gratitude. We are here today discussing the delayed National Guard response to the Capitol for one reason and one reason only. Donald Trump dispatched an armed mob to try to overturn the election he knew he lost. And for 3 hours and 19 minutes, as that violent mob assaulted law enforcement and hunted for members of Congress and the vice president who they were trying to hang, the National Guard was forced to wait and wait and wait. All because of the chaos at the Pentagon caused by the commander-in-chief and the fear that he would involve the military in domestic political affairs, a big no-no we teach worldwide to emerging countries. This was a commander-in-chief who, as the riot unfolded, didn't call his acting Secretary of Defense or Secretary of the Army to ask why the National Guard was missing. Where were they? A commander-in-chief who, after he learned someone was shot, didn't care. He didn't call the National Guard directly. A commander-in-chief whose aides and family partied and danced as the mob prepared to overturn the Capitol. A commander-in-chief who sat in his dining room watching it all unfold on TV like it was an action movie with an ending favorable to him. How did we get here? Let me tell you. In response to the June 2020 demonstrations responding to the murder of George Floyd, President Trump said he would, quote, deploy the United States military, end quote, to put down the protest, and even asked Secretary of Defense Mark Esper why the military couldn't just, quote, shoot the protesters in the legs or something, end quote. Secretary Esper found the president's comments so disturbing, he held a press conference saying he opposed invoking the Insurrection Act. Then, in December, as Trump continued to spread conspiracy theories supported by members of this Congress sitting here today about the election being stolen, talk of invoking the Insurrection Act reached a boiling point. It got so bad that his own Secretary of the Army and the Army Chief of Staff, a 4-star general, issued a joint statement saying, quote, there is no role for the U.S. military in determining the outcome of an American election, end quote. And as our top military leaders worry the president will declare martial law, the rest of the national security apparatus was in total disarray. People were getting fired or resigning left and right. Everyone remembers that, right? And with only 71 days left in his term, Trump terminated the Secretary of Defense and replaced him with an acting Secretary of Defense who was completely over his head. Contrary to attempts to rewrite history, the January 6th Select Committee conducted more than 24 interviews and reviewed over 37,000 pages of documents related to the National Guard and dedicated 46 pages of its final report to this issue. The Select Committee found that the chaos led to an ill-equipped acting Secretary of Defense issuing an unclear order to the Secretary of the Army, an order so unclear that it was interpreted differently by the acting Secretary of Defense, the Army Chief of Staff, and the Secretary of the Army. 3 people, 3 different interpretations. It's all there in the Select Committee's final report and the dozens of relevant transcripts available online. Adding to the chaos, these top Army officials exercised extreme caution and imposed unprecedented restrictions
on when and how to deploy the Guard on January 6th. This was a direct result of the President's decision to involve the military in domestic affairs. To our witnesses, I am so sorry. I am so sorry that Trump's Defense Department and Army leadership failed you and they failed us on January 6th. You should never have been forced to sit on your hands while we were lying on our stomachs, planning to use a pen in our purses as a weapon to defend ourselves against the mob that was sent here to kill us by the President of the United States of America. We were preparing to die. I yield back.
The gentlelady yields. Chair now recognizes the full committee ranking member, Mr. Morelli, for 5 minutes for the purpose of making an opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses for your careers of distinguished service. The DC National Guardsmen are known as the Capitol Guardians, and we as members are only able to do our jobs in the days and months that followed January 6th because you stood guard over us as you did, and for that and for all of your long service, we owe you an enormous debt of gratitude, so thank you. I want to be clear, we're here today for a single reason. An unpatriotic, cynical, power-hungry man incited a deadly insurrection as part of his months-long effort to overturn a free and fair American election. We're here because of his lies about the 2020 election. It's hard to believe. It's frankly even hard to say, but it doesn't make it any less true. Yet many cannot bring themselves to acknowledge it, many in this room. As a result, we're here because of the majority's 15-month quixotic mission to find malfeasance from the January 6th Select Committee who investigated the insurrection where no malfeasance exists. And frankly, just as a question of jurisdiction should be raised, if this hearing is about the chain of command and or communication between the various elements of the defense apparatus of the United States, then it falls to the House Armed Services Committee to do that investigation. They should be doing it, I do agree, but this is clearly not the venue for this to happen. I do want to address something at the outset. There is a notion that persists that President Trump ordered or pushed for 10,000 National Guard troops ahead of January 6th. It's been debunked repeatedly, and it's also a red herring, and here's why. As the chair has stated, a 1969 executive order delegated authority of the DC National Guard to the Secretary of Defense, who in turn delegated that authority to the Secretary of the Army. But the President of the United States ultimately sits atop the chain of command. What he did with the National Guard before January 6th doesn't matter compared to his actions, or I should say inactions, on the 6th of January itself. And what he never did on the 6th was call the Secretary of Defense, the Secretary of the Army, or the DC National Guard itself to find out why they were not on the scene or to order them to the Capitol for that 3-hour and 19-minute delay. So I want to quickly dispense with the claim once and for all that he'd ordered 10,000 troops, as he has said. Acting Secretary of Defense Christopher Miller was asked the following questions and provided the following answers under penalty of perjury. First question, the 10,000 troops, did you take that as a request for you or an order for you to deploy 10,000 troops? His answer, and I quote, no, absolutely not. I interpret it as a bit of presidential banner or President Trump banner that you're all familiar with, and in no way, shape, or form did I interpret that as an order or direction. He was also asked, in February of 2021, Mark Meadows said on Fox News that, quote, even in January, that was a given as many as 10,000 National Guard troops were told to be on the ready by the Secretary of Defense. Is there any accuracy to that statement? Mr. Meadows' answer, not from my perspective. I was never given any direction or order or knew of any plans of that nature. So no, there was obviously, we had plans for activating more folks, but that was not anything more than contingency planning. And then a few questions later, to be crystal clear, the question was, there was no direct order from President Trump to put 10,000 troops to be on the ready for January 6th. Is that correct? His answer, quote, that's correct. There was no direct order. There was no order from the president. I think that's all you need to know. Under oath, the Secretary of Defense said it never happened. Here's the bottom line. The President of the United States manipulated his followers into believing the election was stolen from him, summoned an armed mob to Washington, and then unleashed them on the United States Capitol, and then did absolutely nothing to stop what unfolded. People died. We almost lost our democracy. We could have 100 hearings to deflect blame, but the facts are not going to change. President Truman famously had a sign on his desk that said, "The buck stops here." President Trump's sign, on the other hand, would read, "The buck stops anywhere but here." He lit the fire, he fanned the flames, the Defense Department delayed the troops, and he wants everyone else to take the blame. Frankly, I find it pathetic. I agree with Senator Mitch McConnell, who said former President Trump's actions preceding the riot were a disgraceful dereliction of duty. Former Speaker Kevin McCarthy said Trump bears responsibility for his actions, no ifs, ands, or buts. And I agree with Senator Lindsey Graham, who said, "All I can say is count me out. Enough is enough." I only wish that they and the rest of the Republican Party agreed with their prior versions of themselves. And with that, Mr. Chairman, I yield back.
The gentleman yields. Just for the record, this hearing is not being done in isolation. It's been carefully coordinated with the House Armed Services Committee, and not only has their blessing, but a bipartisan blessing to hold this hearing. Also, without objection, I'd like to submit for the record Secretary Miller's transcribed interview under oath to the Select Committee on January 6th. 2 excerpts. So, Mr. Miller, did you try to read, well, let me back up. On January 3rd, did you have, or even prior, did you have all the authorities needed in terms of activating, deploying the DC National Guard? And he said, yes, I felt I did. Did you need any additional authorities, or was there a discussion about your authorities in any way at the January 3rd meeting? No, I didn't. I felt like I had all the authorities I needed and did not need to discuss anything with the president regarding authorities. Another question. So, Mr. Miller, did you try to reach President Trump that day? I did not. Why not? I had all the authorities I needed to perform my duties, responsibilities that day, and didn't need any other guidance from the president. I now recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes for an opening statement.
And let me start, Mr. Chairman, by submitting for the record the Army timeline of events from December 31st, 2020 through January 7, 2021. That report dated January 7, 2021.
Without objection.
I find some of the comments this morning interesting because I too was on the floor that day. And I find it interesting because there's an allegation that the commander-in-chief has to call everybody who's in the chain of command to make sure his orders are followed. It is my understanding, and I believe that the evidence today will show from these gentlemen who have given their time and are whistleblowers, meaning they're coming forward with something that other people may not want to have heard, that we will discover through their testimony that in fact, the president had given the instruction, perhaps misunderstood on January 3rd, but certainly on January 6th, prior to that instruction being relayed by his officers in accordance with the general military procedure to the DC National Guard. And that's a big part of what this hearing will be about today. And I think it's important that we keep that in mind. Further, we've heard a lot about the attempts to rewrite history because the January 6th committee is allegedly supposed to have already done all of this. But we will hear, I believe, from these gentlemen today that they were not talked to by the January 6th commission. And further, that commission will forever in history be tainted because it was the first time in history, in an attempt to write the history after the fact, that both sides, both major parties in this political situation that we have found ourselves in for the last 175, 200 years, both were not invited to participate in an equal manner. That the Republican representatives who were supposed to be on that, who was originally set up, were supposed to be a part of the January 6th committee, were not allowed to be present. They were not allowed to cross-examine witnesses. They were not allowed to ask for witnesses like these four brave gentlemen who are here with us today. They weren't allowed to call those witnesses to appear in front of the January 6th committee. So while the January 6th committee may have found some very interesting information, they intentionally chose not to tell the truth, the whole truth, and nothing but the truth. At the very best, it can be described as a partial attempt to put forward facts that favored their side of the narrative and not to get to all the facts. And as Jack Webb and his famous character from Dragnet used to say, the facts. We just want the facts, ma'am. That's what we're here to do today, is to try to make sure that we're getting to the facts, not the political rhetoric, not the emotions per se, but the facts from four brave gentlemen who serve our nation and have served our nation, who have come forward. I don't know any of these gentlemen. I don't believe any of them has a political axe to grind. They are here just to deliver the facts. I yield back.
The gentleman yields. Without objection, all other members' opening statements will be made part of the hearing record if they are submitted to the committee clerk by 5 p.m. today. Pursuant to paragraph B of Committee Rule 6, the witnesses will please stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show the witnesses have answered in the affirmative, and you may be seated. I will now introduce each of our witnesses. Our first witness is Command Sergeant Major Michael Brooks. Command Sergeant Major Brooks' military career spanned 29 years with combat tours in Iraq. Command Master Sergeant Brooks spent the end of his career in the D.C. National Guard, including at the Joint Task Force D.C. Mr. Brooks now works at a company that seeks to protect national and economic security from undue foreign influence. On January 6, 2021, Mr. Brooks was a senior enlisted advisor to Major General William Walker and advised on all enlisted matters. Our next witness is Colonel Earl Matthews, a decorated military veteran with a long and accomplished career in government and the private sector. Colonel Matthews served as Deputy Assistant to the President and Senior Director for Defense Policy and Strategy on the National Security Council staff. He also served as the Army's Acting General Counsel and Principal Deputy General Counsel, as well as the Deputy Legal Counsel to the Chairman of the Joint Chiefs of Staff. On January 6, 2021, Colonel Matthews was the Chief Legal Advisor to Major General William Walker and was with him all day. Our next witness is Brigadier General Aaron Dean, with a similarly accomplished career in military service. Brigadier General Dean served in Operation Desert Storm and a combat tour in Iraq. He also served in the D.C. National Guard for over 35 years, exemplifying what it means to be a Capitol Guardsman. On January 6, 2021, Brigadier General Dean served as Major General Walker's Adjutant General and Principal Advisor. Our final witness is Captain Timothy Nick, an active duty service member in the Florida National Guard. Captain Nick has experience in law enforcement, including as a current officer in the U.S. Secret Service. Captain Nick previously served in the D.C. National Guard's Public Affairs Department. On January 6, 2021, Captain Nick was the aide-de-camp to Major General William Walker and took detailed notes of actions of Major General Walker on that day. Thank you, gentlemen, for your service to our country and your strength and courage to come forward and share your accounting of events on January 6, 2021. We all look forward to your testimony. As a reminder, we have read your written statements and they will appear in full in the hearing record. Under Committee Rule 9, you are to limit your oral presentation to a brief summary of your written statement, unless I extend the time period in consultation with Ranking Member Torres. Please remember to turn on your microphone using the button in front of you so that members can hear you. When you begin to speak, the light on the timer in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes has expired, and we just ask that you please wrap up your comments at that moment. I now recognize Command Sergeant Major Michael Brooks for 5 minutes.
Good morning, Chairman Loudermilk, Ranking Member Torres, and members of the subcommittee. Thank you for the opportunity to testify today. I am Command Sergeant Major Retired Michael F. Brooks. I am the former command senior enlisted
Mr.
leader.
Brooks, I'm sorry to interrupt. Could you pull the microphone a little closer to you? People in the audience are having a hard time hearing. I apologize for that. You can start over and we'll reset your time.
Thank you. Is that better? Yes, sir. Good morning, Chairman Loudermilk, Ranking Member Torres, and members of the subcommittee. Thank you for the opportunity to testify today. I am Command Sergeant Major retired Michael F. Brooks. I am the former Command Senior Enlisted Leader of the District of Columbia National Guard, the Capitol Guardians. I retired on March 1st of 2023 with 29 years of active federal service in the Army and the Army National Guard. While I am no longer in service, I continue defense of our great nation as a compliance and investigation specialist with the Compliance and Adjudication Division of the Office of Information and Communications Technology and Services of the Bureau of Industry and Security. I served as the Command Senior Enlisted Leader of the DC National Guard from December 2017 to December of 2022. As the most senior non-commissioned officer in the organization, I reported directly to Commanding General, and from 2017 until his retirement and selection as the 38th Sergeant at Arms for the House of Representatives, my commander was Major General William J. Walker. As his senior enlisted advisor, I reported only to him, and I was with him throughout the days before, the day of, and the subsequent weeks and months that followed the events of January 6, 2021. So imagine my surprise when the DODIG released their report without once interviewing myself or other critically significant DC National Guard members with firsthand knowledge of what occurred that fateful day. Not anonymous witnesses or anonymous officials, but senior ranking military members that were in the room, on the calls, and on the secure video teleconference. I'm not here to disparage the Army that I love and served for nearly 3 decades, but to correct the record and speak for the hundreds of enlisted soldiers and airmen of the DC National Guard who have always answered the call to serve without political bias or prejudice, who have always faithfully fulfilled their oath to support and defend the Constitution of the United States against all enemies, foreign and domestic. Those Capitol Guardians who continue to do so even today after being degraded by senior officials of the Army and the Army staff in their inaccurate and biased report. I believe those who steered the narrative of the DODIG report did so not for historical documentation or to enhance future military response capability, but to protect and advance individuals who sought to shield themselves from responsibility, to overly enhance their role and perceived significance in a critical moment in the history of our nation's democracy. In truth, their actions, no matter how innocent they believe them to be, have led to an awful mark on our military and shown an incredible lack of respect for the service of the men and women who serve in the DC National Guard before, during, and after January 6th of 2021. Trust in our Army's most senior leadership was lost. Their actions and comments have highlighted the Army staff and the Secretary of the Army's lack of knowledge and understanding of the DC National Guard, its authorities and capabilities. Prior to the protests following the murder of George Floyd in May of 2020, I do not believe any of them understood just how unique the DC National Guard is, and the responsibility that is delegated from the President to the Secretary of Defense and further delegated to the Secretary of the Army. I believe it is this lack of understanding that led to the significant delays in the military response on January 6th. I will not sit here today and say if we had been given authority to immediately respond when Chief Sun, the chief of the Capitol Police, made that first frantic call for support at 1:49 p.m., that we would have prevented the breach of the Capitol. What I can tell you with absolute certainty is that we had a force equipped and ready to respond. And that despite the inaccuracies of the DODIG report, we had a plan and would have liked the opportunity to try. Instead, we waited for hours, less than 2 miles east of the Capitol, knowing our Capitol had been breached and not understanding why we had not received the authorization to respond. I cannot tell you the number of times someone has asked me, where were you? Where was the National Guard? Or how can you call yourselves Capitol Guardians? There's no easy response to those questions, and the truth is, we were there and we were ready. We just weren't authorized to respond, and that is difficult to explain. The soldiers and airmen of the DC National Guard deserve better. They deserve to be recognized for their sacrifices over a prolonged period of civil unrest from May of 2020 to May of 2021. I look forward to your questions you may have. Thank you.
Thank you, Sergeant Major. I now recognize Colonel Earl Matthews for 5 minutes.
Chairman Loudermilk, Ranking Member Torres, members of the subcommittee, good morning, and thank you for the opportunity to appear before you today. My name is Earl Matthews, and I'm a colonel in the United States Army Reserve. I'm in the 25th year of my military service. I love our Army, and I'm committed to our Army values. I'm here today because two senior general officers of the United States Army, General Charles A. Flynn and Lieutenant General Walter E. Pyatt, have acted contrary to those values. Generals Pyatt and Flynn have lied to Congress, to federal investigators, and to the American people about why it took so long for the District of Columbia National Guard to deploy to the U.S. Capitol on January 6, 2021. Their distortions contributed to a deeply and fundamentally flawed Department of Defense Inspector General investigation and to deficiencies in other official inquiries. On January 6, 2021, I was on duty and present during numerous conversations, video conferences, and phone calls leading up to, during, and after the riot, which was engulfing the Capitol. When I say these general officers lied, I do not do so lightly or cavalierly. I speak from personal knowledge, having interacted with them on January 6th in my official military capacity. Unfortunately, some senior officials within the Department of the Army and the Department of Defense have sought to protect or to promote Generals Flynn and Pyatt. These senior civilian officials have excused, condoned, or overlooked the misconduct of these officers. As a former acting general counsel of the Department of the Army and its chief legal officer, I take these matters seriously, even if others don't. I'm glad the subcommittee has an open mind and is committed to the dogged search for the truth. In my formal statement, which I provided to the committee in advance of today's hearing, I detailed General Pyatt's and General Flynn's intentional misrepresentations to the Congress and to federal investigators. During today's hearing, I hope to discuss with you how they lied, where they lied, and in my opinion, why they lied. Thank you very much.
Thank you, Colonel Matthews. I now recognize Brigadier General Aaron Dean for 5 minutes.
Good morning, Mr. Chairman, Ranking Member, members of the subcommittee. Good morning, I'm Brigadier General retired Aaron Dean. Let history record this moment as I, in my capacity as the second in command of the District of Columbia National Guard, entrusted with the sacred duty to advise and assist the commanding general on matters of operational significance concerning the deployment of the District of Columbia National Guard on January 6, 2021. Address the grave assertions and inaccuracies contained in the Inspector General's report, DOD IG 2022-039. I believe it is my duty and moral obligation to stand before you today and illuminate the truth. I stand resolute, bearing witness to the unwavering readiness and unparalleled dedication of the service members of the District of Columbia National Guard. I will answer questions honestly, as witnessed through the lens of my 34-year career in the District of Columbia National Guard. I rebuff in the strongest terms the insidious insinuation that the District of Columbia National Guard faltered in its duty, that it languished in apathy or incompetence when called upon to safeguard the sanctum of democracy. Today, I will tell the truth to the best of my recollection, unblemished by falsehoods, and in doing so, exonerate the honor of the brave soldiers and airmen who stood unwavering in the defense of our nation. May my testimony serve as a testament to the indomitable spirit of those who answered the call of duty on that historic day. Thank you.
Thank you, General Dean. Now recognize Captain Timothy Nick for 5 minutes.
Mr. Chairman and members of the subcommittee, my name is Timothy Nick, and I'm a captain in the Army National Guard. I'm here today to aid the subcommittee in resolving factual errors in the official record of what happened on January 6, 2021, specifically regarding the alleged District of Columbia National Guard delayed response caused by critical presidentially appointed, Senate-confirmed Pentagon senior officials. I was concerned by the events that unfolded that day on the United States Capitol. As a federal officer of the United States Secret Service and a former state trooper with the Florida Highway Patrol, my heart goes out to all law enforcement officers, sisters and brothers that held the line that day to restore public order to the chaos. I'm here today with my counsels, Lachlan McKillen and Dan Meyer of law firm Tully Rigney. The firm has advised me, beginning with my role as a confidential source to the Select Committee to investigate the January 6th attack on the United States Capitol. When my confidentiality was breached, it was Dan who intervened to ensure I was protected as a military whistleblower. First, I want to explain my role on January 6th. I was assigned as aide-de-camp, the personal assistant to Major General William Walker, the commanding general of DC National Guard. It was my only second day on the job. Please focus on alleged facts found in the November 16th, 2021 Department of Defense Inspector General's multidisciplinary review into the DC National Guard response and Department of Defense's role that day. I can say unequivocally that the Inspector General's review is riddled with inaccuracies, misstatements, and perhaps false flags and narratives regarding how critical Pentagon senior officials responded when our republic was under great stress. For instance, during a conference call at 2:31 p.m. with members of United States Army, U.S. Capitol Police, Metropolitan Police Department, District of Columbia Government, and U.S. Secret Service Uniform Division, the U.S. Army's Lieutenant General Walter Pyatt, Director of Army Staff, and the Army's Lieutenant General Charles Flynn, Director of Chief of Staff of Operations, were on the call. Also was Colonel John Lubis, Executive Officer to the Secretary of the Army. The Army falsely denied that General Flynn was ever on the call. This is false and material on its face. Lieutenant Flynn was on the call and even participated in discussions. The Defense Inspector's review also rounds language, papering over the fact that Lieutenant General Pyatt and Lieutenant General Flynn, while on the call, discussed how they did not like the optics. That is a direct quote. And they stated it would be in their best military advice to recommend to the Secretary of the Army, Ryan McCarthy, to deny the request from Command General William Walker to deploy the DC National Guard and aid U.S. Capitol Police in restoration of order, liberty on Capitol Hill. In addition, former Secretary of the Army Ryan McCarthy claims he was on a 2:31 p.m. call and spoke on that call. This is false, unless he was in the room shadowing the call and he did not speak nor identify himself. He was not on the call. He was en route to Washington, D.C. Regional Office at the Federal Bureau of Investigation to support that agency's concept of operations plan for January 6th. He went on to claim that he called and spoke to Major General Walker at least twice, ordering the deployment of the DC National Guard. This is also false. At no time did General Walker take any calls, nor did we ever hear from the Secretary on any of the ongoing conference calls or the secure video teleconferencing throughout the day. This I know because I was with the Command General the entire time recording events. Throughout the day, Major General Walker told by staff officers to stand by with respect to deploying to the Capitol Hill. Only at 5:09 p.m. in the early evening, which I wrote down in my wheel book, was the DC Guard given order to deploy and move to the Capitol to assist Capitol Police. We arrived too late. One American lay dead with other sisters and brothers injured, including federal and local law enforcement officers. We were ready and standing by. I know if we were able to deploy immediately when General Walker made the request, the National Guard could have helped end civil disturbance and restored public order quickly. The Army National Guard motto is always ready, always there. The DC National Guard was ready to help and assist Capitol Police, but we were not allowed to do our job due to paralyzed decision-making by Acting Secretary of Defense Chris Miller and Secretary of the Army Ryan McCarthy. This led to federal leadership in the Pentagon. This led to a crisis in federal leadership at the Pentagon and delayed the DC response by 3 hours and 19 minutes. Thank you for the opportunity to appear before you today and articulate the facts as they happened. I look forward to answering any questions you may have.
Thank you, Captain. And as we begin our question session, I want to reemphasize how much we appreciate all of you coming forward. I know as a veteran of the Armed Forces myself, this takes an incredible amount of courage to come forward and tell the truth. We'll now move into the questions session, and I begin to Yeah, just a reminder that make sure the microphones are very close to you during this time. I now recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
We have a sergeant major, a colonel, a brigadier general, and a captain. Your testimony is compelling. Thank you. Now to the questions. On January 6, 2021, were each of you gentlemen with Major General William Walker from 1:49 p.m. through 5:55 p.m., yes or no?
Yes. I was.
Yes.
Yes.
The Department of Defense Inspector General report, DODIG report, alleges that the Secretary of Army contacted Major General Walker multiple times on January 6 during that time frame. Some allegations are 2 calls, some are 3, but the allegations would be, or the assertions would be, 3:04 p.m., 4:35 p.m., and finally at 5 p.m. Do any of you recall any one of those calls taking place?
Negative, sir. Can I amplify that though?
Yes, sir.
So, by way of background, I was a political appointee in the Trump administration. I was a senior political appointee. I was also a guard. I was also in the Army Reserve and National Guard. Now, in June of 2017, I was appointed to be acting general counsel of the Department of the Army. The next month, Ryan McCarthy was appointed acting Secretary of the Army. He'd been confirmed as Undersecretary of the Army. So Ryan McCarthy was my colleague. He was my friend. I told the committee he was a good Secretary of the Army. I had a great deal of affection for Ryan McCarthy. I know he did for me. So I'm not here to badmouth Ryan McCarthy, but I've got to set the record straight.
Yes,
Now,
sir.
in my memo, I called Pyatt and Flynn liars. I never called McCarthy a liar for 2 reasons. One, it wasn't clear to me that he was saying some of the things they said he said. I mean, it appeared to me that some of the things they said he said were said by others who were trying to really protect themselves. The other thing was, he was my friend. You just don't turn it off. You don't call your friend a liar. So, but at 2:30, at 2:31, at the 2:30, they said that he was on a call with General Walker, and he told him to move the QRF to the Armory. I mean, that did not happen. Ryan McCarthy didn't speak on that call. And we know this because that call was on a conference bridge. It was a DC government conference bridge. Now, the DODIG incorrectly states that McCarthy requested the call. I helped facilitate that call. General Walker was on a call with Dr. Rodriguez, who was the Homeland Security Advisor for Mayor Bowser. Mayor Bowser was on a call. Chief Son was on a call. Chief Conte was on a call. All of us at this dais were all on a call. Ryan McCarthy never spoke on that call. I'm a person who was his friend, who knew his voice quite well. If he had said anything, I would say that. We were told he was unavailable. I called his executive officer to ask to speak to him, and we were told he was unavailable. General Walter Pyatt and General Charles Flynn were on the call. Subsequently, Flynn denies he was even involved in the call. For what reason, I really don't know. He did so under oath, and Command Sergeant Major Brooks, myself, and Lieutenant Nick were all interviewed by the Select Committee. We told them that. To me, this is material because Flynn denied under oath twice to the House Oversight Committee and to the Select Committee that he was even participated in the call. That goes to his integrity, to his credibility.
All right,
And I'm sorry.
let me underline this. Colonel, you are also an attorney.
Yes, sir.
You
With a
got
law
your
license.
degree from Harvard Law School.
Sir, I got a mortgage in Great Falls, Virginia. I have no reason to be up here lying because I don't want to go to federal prison.
And you understand that you are, if you lie to Congress, Title 18-1001 makes that a crime. Is that correct?
Unquestionably, sir.
And you also understand that as a member of the legal establishment, that if you were to lie under oath, your license to practice law, no matter the fact that you have a JD from Harvard, could be in jeopardy. Is that
No
correct?
question, sir. And sir, I want to point out.
Yes, sir.
I spoke to the Select Committee. I was not under oath, but it doesn't matter because you don't have to be under oath. If you lie to Congress, it's still a federal crime.
Yes,
and
sir.
I'm fully aware of that. And I submitted a document stating that these men were liars, and I stand by it 100%. And it's the stain on my army that they got away with it. No one said anything about it. And they even sent Pyatt's name to the President of the United States to have him promoted. He was a liar. And all of us can attest to that.
And you want the truth to come out?
No question about it, sir.
Good, bad, or ugly, correct?
Exactly.
Anybody here want anything but any of the 4 witnesses want anything but the truth to come out?
No, sir.
Good, bad, or ugly, doesn't matter, no matter what side you're on. Is that correct? I heard a yes, a no, sir.
Yes,
You
sir.
want the
Yes,
truth?
sir. Nothing but the truth. Yes, sir.
Yes.
Colonel Matthews,
Correct.
Brigadier General?
That's correct.
That's correct. Yes.
Captain. All right. Well, I don't know. I got lots of other questions to ask, but I appreciate you jumping in and clearly with your heartfelt emotions telling us that things weren't exactly true and that in fairness, the January 6th committee was not told the truth. Is that correct, Colonel?
Well, so they were not told the truth, but I think they knew that though, and they disregarded that. And this is what I mean. So General Flynn testified before the House Oversight Committee on June 15th, 2021. During his opening statement and during his questioning, he stated explicitly that he was not on that phone call. He made no statements on that call. Subsequently, he was interviewed by the January 6th committee, and he also stated he was directly asked by the senior investigative counsel, "Did you make any statements on that call?" He says he did not. He was not on the call, he says. Now, that is perjury in my opinion. I mean, I'm a lawyer, but it's for court to decide, but to me, that's perjury. But the important point is, later, I raised that. I was interviewed by the select committee in December.
Unfortunately, my time is up, but hopefully you'll get another opportunity to talk about it. All right, I apologize. My time is up. I yield back, Mr. Chairman.
Gentleman yields and now recognize the subcommittee's ranking member, Ms. Torres, for 5 minutes.
Colonel Matthews,
Yes, ma'am.
I spent more than 17 years as 911 dispatcher. I worked through some very difficult times in the city of LA, Rodney King riots, the verdicts. On 9/11, I was tasked with putting together mobile field force units to dispatch to critical locations to ensure that those would not be attacked. So I know what an EOC is supposed to look like. I know what orders to follow during certain types of emergency. I was prepared with a manual that was provided to me, things that we have practiced time and time and time again. During an emergency, you agree that it is vital that we have a quick response and a unified coordination that has clear communications, correct?
No question.
I was struck by your written testimony when you said the DC National Guard was delayed because Millie McCarthy and McConville believed that the President of the United States might deploy the National Guard improperly on that day and had taken measures to prevent this. This must have been incredibly frustrating for you and for your colleagues in the Guard. Why do you think senior military leaders believe the President of the United States might employ the National Guard improperly on January 6th? Was it based on their words, actions, or both?
I think that I think that belief was irrational because I don't believe the president ever gave any of them an unlawful order.
Okay.
He gave none of them an unlawful order.
Secretary
He
Secretary
appointed all
of
of
the
them to high
Army,
office.
Ryan
Appointed them all to
McCarthy
high office and they-
testified that on January 6th Select Committee, that at one point he was walking down the Pentagon hallways, and one of the most seasoned reporters asked him whether the Army was planning to seize ballot boxes. Do you know if ideas like the president seizing ballot boxes was something Secretary McCarthy was considering when making decisions about deploying the Guard on January 6th?
I think it was, but I think it was not a rational belief. I think,
Okay.
so Secretary
Wa- wa-
McCarthy
Was
says.
there widespread fear within the Department of Defense about the president using the military or
No.
other levers of the state to impact the election around the time of the 2020 election?
No, so it was not a widespread fear. It was a fear among a clique of officers led by the chairman of the Joint Chiefs of Staff who talked about a so-called Reichstag moment.
Okay,
and,
well, let me
who-
tell you, the New York Times reported in January 2022 that President Trump actually directed his attorney, Rudy Giuliani, to ask the Department of Homeland Security to see if it could legally take control of voting machines in key swing states. I'd like to ask for unanimous consent to enter this New York Times article entitled "Trump Had Role in Weighing Proposals to Seize Voting Machines" into the record.
Without objection, so ordered.
Command Sergeant Major Brooks, you served in the Army and Army National Guard for 29 years. You spent the months after January 6th right here on this Capitol Hill protecting the citadel of democracy. I understand that for the entire time that you were deployed, you slept in your office, with the exception of maybe 1 week over the course of months. You clearly are a patriot who loves our country. How did you feel watching the Capitol get overrun, knowing that you were almost walking distance away, but not permitted to come assist law enforcement in defending it?
It was very disheartening to see. I believe it was something that, I think any of us who serve in the military was something that we didn't think we would see in our lifetime. It was very frustrating to know that we had the capability and the personnel and unable to respond.
Thank you.
It's hard to describe.
Brigadier General Aaron Dean, what is the basis and rationale on which the Department of Defense and DC National Guard rely in determining the equipment, tactics, techniques, and procedures that the Guard could use to respond to escalations in the protests on January 6th? Was this atypical?
I don't think it wasn't atypical.
We were just we right now are just months away from the 2024 election, and the man who incited the 2020 insurrection is on the ballot again. What corrective actions has the National Guard Bureau of Department of Defense taken to ensure the National Guard can plan, coordinate, and execute command and control in response to threats in the national capital region?
I can only really talk about the District of Columbia National Guard and its preparation, especially around January 6th. We match capability with request. So if there's a request, we match the capability that we have. And we had riot control capability on that day to provide services for the Capitol.
So you would say that over the last 4 years, the smoke has been cleared and everyone is clear on how to respond, and politics will not take priority over necessity?
I can say that the District of Columbia National Guard is always ready to respond.
Thank you, sir.
And was ready even before that date.
Thank you, and I yield back.
Gentleman yields back. Now recognize Congressman Diaz-Pasito of New York. 5 minutes.
Thank you, Mr. Chairman. First question for everyone. We could start and just go down the line. Did you testify in front of the January 6th Select Committee?
No, I received a phone call.
You say testified, I had an informal interview with the.
Right, but it was
You can move
not
the mic
archived,
closer.
correct?
I'm sorry, say again?
If you could move the mic closer, please. We'll give you a couple extra seconds.
So the answer,
It's no.
Command Sergeant, was no.
No.
Colonel, you were interviewed but never in front of the committee.
Correct.
Brigadier General?
No.
Captain?
Informally interviewed, but never in front of the committee.
Okay, got it. So as the chairman mentioned in his opening remarks, we're here today to not only correct the record, but also make sure that we are better prepared today than we were, right? We want to be better prepared as a nation, as an agency. We want to be better prepared for the next, God forbid, incident than we were that day, not really to focus on President Trump. That's not really what we're here for today. So Captain Nick, in your opening testimony, or the one submitted to the committee, you said that at about 2:30 conference call, and I quote, Lieutenant General Piat and Lieutenant General Flynn, while on the call, discussed how they did not like the optics. They stated it would be in their best military advice to recommend to the Secretary of the Army, Ryan McCarthy, to deny the request from Command General William Walker to deploy the DC National Guard and aid the United States Capitol Police in the restoration of ordered liberty, or as some called on this committee, democracy, on Capitol Hill. Major Brooks, during the bipartisan transcribed interview the subcommittee conducted in March 2024, you were asked if you recall hearing the word optics on your 2:30 p.m. phone call. You responded, yes, and I quote, General Flynn and General Piat both made numerous comments about the optics of having the Guard on the Capitol and how they would much prefer that the Guard relieve MPD officers elsewhere in the city so that they could respond to the Capitol, close quote. For everyone, and we'll start with Command Sergeant Major Brooks, why would these military experts want to send the National Guard to relieve MPD officers elsewhere after the Capitol was breached at 2:12 p.m.?
In my opinion, it was a senseless recommendation. The logistics and the amount of time it would have taken to replace individual MPD officers across the city would have taken way too much time, and it would have been further delayed.
I think the key term there is senseless. Colonel.
So their whole attitude was that this mission was for law enforcement. They never wanted DC Guard to be in the streets in the first place. They didn't ever want to approve the 350. They thought this was a law enforcement mission. they believed it would have required 100,000 demonstrators before the DC Guard was necessary. And that was the Army's thinking. So they wanted, and they also said they wanted no involvement in the politicization of the, or no involvement in the electoral certification process. No, they wanted no DOD role there. So that was their attitude. So we were not allowed to be east of 9th Street, so, which is where the Capitol is. We're not, we had to have the Secretary of the Army's approval to move 3 unarmed guardsmen 1 block.
Right. So sounds like baseless decisions. Brigadier General.
So I did hear the word optics, and they did use it, especially specifically General Pyatt, I know, said optics. And his concern was he did not want soldiers or airmen on the Capitol grounds with the Capitol in the background. And so they were giving every other reason why we should be around the Capitol, away from the Capitol, and not responding to the Capitol. And part of what I believe is I believe that they're unfamiliar with our true capabilities and what we're really designed to do as the National Guard.
Can you say that again for everyone to hear?
I think they're unfamiliar with our true capabilities and what we're designed to do as the National Guard under Title 32.
Precisely. Captain.
I did hear the word optics also, and General Pyatt and General Flynn did say it wasn't in their best military advice to recommend to the Secretary at this time to approve that request.
And I only have 30 seconds, but I would just like to go down the line once again and answer this question. Was it clear at the time that the #1 priority was to restore order or to protect the safety of members of Congress, staff, or visitors here at the Capitol complex? Captain.
Absolutely.
No, that was not.
Oh,
I'm sorry.
it was clear that we needed to be at the Capitol at that time.
Right.
I
You
mean-
needed to be, but was that their #1 priority?
No, it was not.
Brigadier General.
Their #1 priority was to make the police respond and not the National Guard.
Colonel.
Absolutely not, Congressman.
It was not their priority, sir.
Thank you. I think it's clear. Mr. Chairman, I yield back.
Gentleman yields back. Now recognize Mr. Morelli for his 5 minutes of questioning.
Thank you, Mr. Chairman. I want to start my question, and I apologize, I only have 5 minutes, so I'll try to get through some of this quickly. But first of all, appreciate very much your frustration. This was your job to defend the Capitol, and for the reasons both of this hearing and a lot of conversation, you weren't called on to do that. So obviously, it's palpable how strongly you feel about this missed opportunity to defend us, and I appreciate that, and I don't think there's any disagreement here. You should have been here much sooner, and I certainly don't know that anyone argues that it was your fault that happened. I am a little shocked. Mr. D'Esposito said, we're not here to talk about President Trump. To me, that's a little like asking Mrs. Lincoln, other than the incident, how did you like the play? The truth is, the commander-in-chief could have ordered the National Guard. And as I said earlier, and frankly, I think Mr. Griffith said, and I'll have to go back and look at the record, that the president ordered the troops out on January 6th. There's no evidence anywhere that I've heard of other than him saying it. There's literally no evidence of logs from the White House. There's no evidence anywhere that the president did that. And frankly, look, I don't know much about this. I'm a civilian. If I were the president of the United States, as soon as the breach happened, as soon as there was any measure of violence at the Capitol, I would have assembled people in the Situation Room, and I don't care about this. If the Secretary of Defense was there, the Secretary of the Army was there. I'm the Commander-in-Chief of the United States. And so I guess I'd begin, General Dean. If an order came from the White House, from the president, that deployed the National Guard, would that order have been questioned by anyone?
But I would answer it this way. I would say that order was delegated. The responsibility of the response from the commanding general was written in a written document to him that basically gave him parameters on what he could do and what he couldn't do.
So
Now,
I
could the
appreciate
president-
that. I
could-
appreciate that.
yeah.
But I don't believe the delegation of authority exempts the higher authority. If a call came from the president or the White House that the president wants this deployed, if the Secretary of Defense were somewhere, the Secretary of Army were somewhere else, would you have ignored that order?
No, we wouldn't have.
No.
Not at all.
That's, look, and I don't want to draw you into it. I'm just saying those who want to absolve the higher levels of command. Likewise, if the Secretary of Army had not acted, but the Secretary of Defense, Secretary Miller had called, and his office had called General Walker and said, deploy the National Guard immediately, would anyone have questioned that order?
No, No, we wouldn't, I'll speak from my perspective. We wouldn't have questioned it, but we would have wanted it coordinated based on the document that was sent
So you-
by the
so you-
Secretary of the Army.
So not to interrupt you, you would have sought a manner to verify it and to make sure that that was legally the appropriate process, but you would have acted on it immediately, no?
I think the whole thing was, there would have been a conversation, right?
Yeah.
There was this talk about they needed a CONOP, right? A concept of operations.
Yeah,
Well, that's a discussion. In a crisis, that's a discussion.
I agree.
And so with that, there would have been a discussion about the deployment of the National Guard with any order given by any senior official.
Yeah, and I guess I get, and this isn't necessarily a question, but what I hear is a lot of confusion between the White House, the Department of Defense, the Secretary of the Army and his office. I don't know what happened. I guess there's varying accounts. And what I think each of you is here to testify is that the order didn't come down.
Congressman, may I speak to that, please, sir?
Yeah, go ahead.
So chain of command runs from the president to the Secretary of Defense, to Secretary of the Army, to General Walker. Now, the Secretary of Defense authorized the DC National Guard to deploy at 3 o'clock. The DC Guard was able to deploy at 3 o'clock.
Yes.
It had the capability, readiness to go on the street at 3 o'clock. But the order didn't come from the Secretary of the Army. So that was the
No, I understand.
bottleneck there. The president would follow the chain of command. So typically the president, and I must.
No,
remind-
I
must
would
rem-
say this, excuse me, I'm going to reclaim my time. I apologize. Is that if I were the President of the United States and had ordered it, if that were true, there's no evidence that happened, but let's say it had been ordered, and then 20 minutes goes by and nothing's happening, I'll be on the phone again to my secretaries, and I'd be on the phone to General Walker and say, what's going on? I've ordered you out, move out. And with all due respect, conversation should have happened. I don't know if it did or did not, but.
So Congressman, I think that, if the president would have called the Secretary of the Army, the Secretary of the Army would have said, we're moving as fast as we can. We need to be deliberate. We need to know more information. That's what the Secretary of the Army said in sworn testimony,
But
Congressman.
that's not what happened. He didn't say that in his testimony.
He did say that in his testimony,
No,
sir.
he didn't. He didn't say the President of the United States ordered him to do
No,
anything.
he said that if the president would have called, he said it would not have made a difference. The president's call would not have made a difference. Secretary
I
McCarthy.
disagree. Well,
Secretary McCarthy, I think you're right also.
Respectfully,
So-
sir, let me reclaim my time. In fact, my time is over. But the point that I'm trying to make is that I don't disagree. This is an important conversation. I don't think it's one for our committee. I think the Armed Services Committee ought to be holding this. And there is a question to make sure that come January of 2025, we better be damn sure we have communication that is clear, compelling, and chain of command. But I do think there's no way to absolve responsibility of the president, the Secretary of Defense, or the Secretary of the Army. You may dispute what happened, and I think that's fair, but something should have happened that triggered the deployment of the National Guard sooner so that you could have done your jobs, and we wouldn't be having this hearing this morning. So with that, I yield back.
Gentleman yields back, and I agree with him on his last statement that we need to be prepared for the next time that we have January 6th come up, which is in the law. I would also correct the record. I did say the president, the gentleman is correct. That's not in the evidence. The president had previously given Christopher Miller the authority to act, as he stated in his testimony, which was previously submitted into the record. And Christopher Miller is the one who gave the order that did not get followed, apparently, by the Secretary of Army. That being said, I now recognize Dr. Murphy for his 5 minutes of question.
Thank you, Mr. Chairman. I apologize if I'm a little out of breath. It's just being old. Thank you all for coming forward. It takes absolute courage, absolute courage. Every damn meeting we have now has Trump derangement syndrome talking to it. This was a dereliction of duty by the Secretary of the Army, who refused, by the way, to come before this committee because he knew his culpability. He knew that he lied and he was derelict in the duty. And I appreciate from the bottom of my heart you guys standing up for the United States of America. You took an oath to it, as did the Secretary, and you're keeping your oath. So I deeply appreciate it at your own personal cost, because we know the weaponization of this government is occurring at an exponential rate. And it's just it is just proof in the pudding that this is what we're dealing with. I swear, why do we not have bipartisan support in getting to the bottom of this is beyond me. It's everything about Trump. Captain Nick, You know, the summer before in 2020, when there was an absolute disaster in this country where riots and burning of federal buildings occur, we saw billions of dollars, multiple deaths occur. Speaker Pelosi, I believe, is culpable with part of this in allowing this, paving the way for the terrible thing to happen on January 6th to just dismiss America's memory of what happened the summer before. In contrast, the protests at Capitol on January 6th, which we know were all wrong, there was no hesitation in creating a politicized community. And we had a former Republican who saw it as a personal grind to go after President Trump, basically not allowing evidence to come before the committee. It's been more than 3 years, and members of the DC National Guard are coming forward with your oath to provide clarity. I'll just ask Captain Nick, in your testimony, you mentioned you were a confidential source for the Select Committee. In addition, you go on to state, my confidentiality was breached to the national media. Would you mind expanding upon that?
Yes, sir. First, I'd like to correct the record from a previous statement from your colleague. When he asked a question about Pentagon officials and their desire to send troops, I said absolutely. I meant they did not at that time want to send troops to the Capitol, just for clarification. I was informally after January 6th, at some time after, I was informally interviewed by the Select Committee on January 6th. I gave informal testimony and hired counsel from Tully Rickney, Dan Meyer, who's also behind me. After giving my written notes and informal testimony, a couple weeks later, I was contacted by Political from a news outlet, from a writer requesting comment on my handwritten notes they got a copy of. I then contacted Dan, who then contacted the Select Committee to resolve that. But it had to be leaked at some point from probably the Select Committee, because that's the only people I talked to and gave my notes to.
It is obviously evident with anybody with an objective eye that the committee was put forth to tell one thing. If that committee had gone in front of anything in a legal department, you would have cross-examination, other witnesses, et cetera. We never saw any of that to get to the actual truth, which is what all Americans, whether you're which party or not, should believe in doing. Period. Period. I just want to reiterate something. This is actually, I guess, to Colonel Matthews and General Dean. Turning to the matter of security, Secretary of the Army and McCarthy have said the DC National Guard was not prepared for immediate deployment. Do you agree with that statement?
That statement is false. We were prepared in many ways. We even had backup plans. We call them branches and sequels, right? So not only did we have a force that was at Andrews Air Force Base that was training and doing civil disturbance that weekend, prepared to deploy on that day, that was ready to deploy on that day. We also had traffic control points that were at MPD, and those members had riot control gear in the trunk, not visible to the public, but for their self-protection. In case MPD had to respond, they had the appropriate gear to provide civil disturbance, riot control efforts if needed. And so we had the capability, we had the planning, we had the know-how. So the question that I have is, so out of all the events, out of all the inaugurations the District of Columbia National Guard supported, out of all the NATO summits, out of all the IMF protests that we've had, the summer of 2020, COVID, we were not able to respond to this. We're incapable. That's categorically false.
I find it just, my time is short, but I just find it a slap in the face to all the good men and women who serve in our armed forces to say you're not prepared. A slap in the face. And because this guy wanted to save his butt with the hope of getting in the Biden administration, that's point blank what happened. Thank you, Mr. Chairman. I'll yield back.
Gentleman yields back after consultation with Ms. Torres. We've agreed to do a second round of questioning, and I would recognize Ms. Torres for her additional 5 minutes of questioning.
Thank you. The claim that somehow the Select Committee didn't investigate the National Guard response to the security failures at the Capitol on January 6th is inconsistent with the facts. As I mentioned, the Select Committee interviewed 24 individuals and reviewed 37,000 pages of documents related to the National Guard on January 6th. Their response And 46 of those pages are in the final report that was issued. If you search the transcripts of those interviews held with these witnesses ahead of this hearing, you'll see the significant number of questions used for testimony from the Select Committee as their foundation. Just because there wasn't a court reporter doesn't mean that it didn't happen. As I told you in the back room, I was in the balcony while all of this was unfolding. I was also witness to an assault on an officer where the door swung open on balcony that I was sitting. But just because they didn't interview me for that incident doesn't mean that any of those investigations did not happen. But let me just remind everyone, about what the president was putting out on social media during that time. At 2:24 p.m., the president tweeted out regarding Vice President Pence not having the courage to do the wrong thing that he wanted him to do. At 3:13, the president had issued another statement saying, "I'm asking for everyone at the U.S. Capitol to remain peaceful, no violence. Remember, we are the party of law and order, respect the law, and our great men and women in blue. Thank you." He didn't tell people to go home. He didn't tell them to go home. It took many of his own closest allies to get him to this point. The president didn't want the violence against the police or against members of Congress or against his own vice president to stop. The truth is, he wanted the violence to continue until he could take custody and continue to keep custody of his position. At 4:17, he finally posts a video that contained many lies about the election, but finally encourages people to go home. And that's when they finally started home. Those are the real facts of what happened on that day. So in addition to under Democratic leadership, and I know that you want to continue to blame Democrats for what happened on that day, but Democrats did not tell the mob, the angry mob that was armed, to go to the Capitol. Democrats are not responsible for that. The request, about this January 6th attack, we have gone back and forth as to who was ordered to do what. That information
from purchasing America's data from third-party data brokers. U.S. government agencies are purchasing Americans' data through a loophole with third-party groups when they would otherwise need a warrant. Recently, the Internal Revenue Service purchased records and locations of millions of American cell phones, and the FBI purchased geolocation data for mobile advertising. The Cato Institute recently reported that data brokers collect and sell huge amounts of Americans' sensitive information, including whether they have an interest in firearms. Data brokers sell lists, in their words, of shooting fanatics, concealed carry license gun owners, and even sell information about America's interest in political organizations. Government agencies like the FBI purchase this information as a loophole to obtain private information about U.S. citizens without a warrant. I am deeply concerned that the practice of buying commercial data could not only threaten America's Fourth Amendment rights, but it could also pose a threat to their Second Amendment freedoms and be used as a way to track and target lawful gun owners in America. We must prevent this. H.R. 4639 will provide the necessary guardrails to ensure that these three-letter government agencies, including the intelligence community, does not and cannot overstep and infringe on Americans' constitutional rights. So why can civilian companies buy this data, but not the government without a warrant? Because the government can take away your liberties. The government can put you in jail. Civilian companies cannot do that. I urge my colleagues on both sides of the aisle to stand with the Constitution and support H.R. 4639. The Fourth Amendment is not for sale act. And I yield back to the chair.
Reserve.
Gentlewoman from Wyoming reserves. Gentleman from New York.
Reserve.
Gentleman from New York reserves. Gentlewoman from Wyoming.
Mr. Chairman, I'll yield 2 minutes to my fellow representative, Mr. Dan Bishop. No, not for this one. Okay. Mr. Chair, I believe that we're ready to close.
The gentlewoman reserves.
Close. Mr. Chairman, I yield myself the balance of my time.
Gentleman is recognized.
Mr. Chairman, data brokers collect massive amounts of information about Americans that can track and identify our most intimate details. It is bad enough that companies have access to all this personal data, but now the government can access this data too without securing a warrant, just by purchasing it on the open market. This amounts to an end run around the Fourth Amendment. This legislation would end this practice and protect our privacy as the Constitution demands. I urge all members to support it. Now yield back the balance of my time.
Gentlewoman is recognized.
Yes. So are we? There are a couple of points, Mr. Chairman, that I would like to make. One is that I reject the notion that in order to beat China or other foreign adversaries, we must become like they are. If the real opposition to this bill is that it prevents the United States government from becoming the same type of surveillance state that communist China is, then I think that says everything that we need to know about those opposed to the bill. And I challenge them to explain that position to their constituents. I am a constitutional, I believe absolutely in protecting our constitutional rights. And I believe that it is important to understand the significance of how these various federal agencies have been abusing this power to surveil and persecute American citizens. As part of the Committee on the Judiciary's investigation into the IRS's troubling visit to the home of journalist Matt Taibbi on the very day that he testified before the Select Committee on the Weaponization of the Federal Government, we learned that the IRS collected personal data from data brokers to use in its investigation of Mr. Taibbi.
Is very clear. There were no clear directions, because if there were clear directions, everyone would have moved in unison. Everybody would have been together, putting together those plans that you said already exist. So, Colonel Matthews, you seem to want to respond. Please go ahead.
Well, ma'am, I just, the committee, so the committee interviewed, again, Command Sergeant Major Brooks, myself, and Lieutenant Nick. We all told them that there are issues with the credibility of several witnesses. The people who have not been responding honestly and accurately as part of the investigation, and that was disregarded. And that goes to the credibility of what they were telling the committee. Like, for instance, the committee says, I'm sorry, the Select Committee stated in its findings that our QRF, it was debatable what its purpose was. There's no debate about that. It was a civil disturbance response force. It was designed to respond to a riot. But General Officer,
I think you're missing the point. There would have been no riot. There would have been no riot had the President of the United States not set up the stage and ordered people and told them that he would join them at the U.S. Capitol. There had been no galley that was erected to hang the Vice President if the President had not want them to stop us from certifying the election. You're missing the point of all of what happened 6 months prior to January 6th, the chaos that was happening within the branches of the military that are sworn to never get involved in domestic affairs. I yield back.
The gentle lady yields. I apologize for a brief absence. I have another committee that a bill got called up right at the worst time that I had to go present. But I think a couple of points of clarification. The Capitol breach began well before the people at the White House made it down to the Capitol. The gallows were actually erected at 6 o'clock in the morning, and no one knew exactly what Mike Pence was going to do until about 1:30 in the afternoon. These are just some of the questions of the narrative that came out from the January 6th report, which is this much. This is how much is discussed about the DC National Guard. The primary objective of the Select Committee was to investigate the security failure at the U.S. Capitol, because we have to identify the failures before we can fix things. There was an entire team, the blue team, who was commissioned with doing that. I challenge anyone to look in here and find anything of substance from the blue team whatsoever. So this is why it's important that we do the oversight that is the job of Congress, and specifically the subcommittee, to look into what happened. This is clearly within the security failure of the Capitol. This should not be political. This should not be biased in one way or the other. Regardless of who was coming to the Capitol, regardless of who broke into the Capitol, that should have never happened. There should have been no breach of this Capitol. The resources are here. And the idea that the New Jersey National Guard would get here before our own National Guardsmen, whose job is to, as Colonel Matthews said, riot control, traffic control. This is their job, to come in and help defend this Capitol. And so, with that, I do have a few questions here. The DOD IG report alleges that DOD officials did not delay or obstruct a response to the Capitol. Sergeant Major Brooks, I'll start with you. Do you believe that the deployment of the DC National Guard was delayed?
Yes.
Who do you believe delayed it?
Secretary McCarthy and senior officials in the Army staff.
Okay. Why do you believe that they delayed it?
I believe their misunderstanding of the capabilities of DC National Guard and the seriousness of the situation, to be honestly, I have no idea why we never received that order. All I know is that they were more concerned with what it would look like with soldiers with the Capitol in the background than protecting the Capitol of the United States.
Colonel Matthews, same question for you. Do you believe that deployment of the DC National Guard was delayed?
Yes, sir. I believe that it was a result of an overcautious, reluctant, hesitant, facilitating leadership. And I think they were concerned about the optics, the political optics of a military presence here. And I don't think they trusted the commander-in-chief. And I think that was because of our senior ranking military officer who was making disparaging remarks about the president to them. You got to remember, the people who ran the Army are very close associates of the chairman of the Joint Chiefs of Staff. They owed this position. They owed their positions to him, and he was not. I mean, there are books about how Chairman Milley was impeding the ability of the president. So I think that was an issue there, sir.
So just to clarify, you think that there was a delay that was calculated for one reason or the other, but you're not indicating that there was a nefarious purpose in that. Just so we don't walk out of here with conspiracy theories that the DOD wanted the Capitol to fail. I just want to make sure that that's not where you're going with that.
I'm not going with that, sir. I'm saying that the conditions were set by this talk of a coup, of a Reichstag moment. I mean, the idea that I mean. Let me be frank about it. A bunch of black kids in the DC Guard are going to usurp the election for Trump. It's crazy, but that's what they were talking about. I mean, and it's crazy talk, and it was out there, and it's in books. I mean, Milley's talked about it.
Well, I've got you, Colonel Matthews. Do you believe the DOD IG report accurately reflects the events of January 6, 2021?
That DOD IG report is replete with incorrect information, false information. Even the Select Committee's report has shown that. And can I give you a couple of examples, please?
Sure.
it says at 16:35, Ryan McCarthy called General Walker and directed him to go to the Capitol. Now McCarthy, if you read his transcript from the Select Committee, he said he never did that. He was getting ready for a news conference. He was taking notes and writing, and so preparing for a televised news conference. And he overheard Brigadier General Leneve direct General Walker to go, but General Leneve says he never told General Walker to go. He never gave a go order. So they do like this. They point in each other's directions and say, so with the DODIG puts it in, and then they claim that they had to call Walker again at 1700, like 25 minutes later, and direct him to go. That's an absolute falsehood. McCarthy was in a televised press conference. Mr. Storch, the DOD Inspector General, has an obligation to correct the record for, I mean, where does he go? Where does General Walker go to get his reputation back? I mean, you smeared this man by anonymous sources, and we're talking about general officers in the Army who were bitter because of Walker's testimony in March before the Senate. They didn't like that, and they wanted to get General Pyatt promoted to general, and so they wanted to take down Walker. Even General Milley engages in that. General Milley engages in that in his, if you read his transcript, sir, from the Select Committee, he implies Walker was lying or exaggerating, and everything General Milley says in his transcribed interview from the committee is incorrect, and the committee staff had to know it.
So let me just clarify something here. General Walker did testify under oath to the Select Committee. Is that correct?
Correct, yes, he did.
The implication of the DODIG report is that General Walker falsely testified. Is that fair?
To the Senate Homeland Security and Government Affairs Committee and to the Senate Rules Committee. He testified in March. In March of 2021, the DODIG report came out in November 2021, and the implication was that he was not truthful in his testimony.
So,
and this is a sitting officer of the Congress of the United States appointed by Speaker Pelosi, a sworn career federal law enforcement executive and a Major General of the United States Army. They were implying that he committed outright perjury on live television.
So,
and I took exception to that. You know, I wrote my memo, sir. I wasn't working for General Walker. I had nothing to gain from that, but it was the right thing to do. This man was responsible for all of your personal safety. He was smeared by it, and I just
okay, let me reclaim my time. There's other questions I need to get to, but I just wanted to make sure that you understand that the implications of the DODIG report is that General Walker falsified testimony or was not truthful. Would you believe that he would be selected to be the head security officer of the House of Representatives by Nancy Pelosi if it was known that he had lied under oath? Okay, I just want to make sure we're talking about someone who was selected by my colleagues on the other side of the aisle to be the sergeant at arms here. I'm just getting to the point. This is a bipartisan issue that we're talking about here. Let me move on real quickly. Captain Nick, the DODIG states they received a copy of contemporaneous notes from Secretary McCarthy's aide-de-camp from January 6, 2021. Did the DODIG request a copy of your notes that day?
No.
They did not ask for your notes?
I never spoke to anybody at the Department of Defense IG's office, and they never requested my notes, and they never contacted me.
No. Okay, interesting. I'll do a couple more questions and we'll continue down the aisle. The DODIG report alleges that on June 20, in June of 2020, that June 2020 taught Secretary McCarthy that he could not simply rely on the DC National Guard to figure out the details. General Dean, what do you make of that statement?
I think that he's unfamiliar with what the DC National Guard can actually do and its true capability. So I think he's probably being advised by senior active component officers that have never spent a day in their life in the National Guard. And they're advising him on what the National Guard should or shouldn't do. It's like a surface warfare officer in the Navy talking about a submariner. You're in the same service, but you do different things. And so I think part of the issue is taking military advice from a senior active component officer about National Guard issues pertaining to civil disturbance or domestic response. I think it's out of their wheelhouse, and I think sometimes they can provide inaccurate information. And in doing so, it creates this lack of trust because now you don't know who to believe. You don't know whether to believe the people that are actually supposed to advise you on military matters or the National Guard. But I would propose to you that you need somebody to advise you on Army and Air Force National Guard matters, not just military matters, if you want to get to the truth.
Okay, thank you. Sergeant Major Brooks, same question, but let me proceed that with, there were a lot of acts of violence, riots throughout the country during 2020. We had that in Georgia. As a response to the riots in Atlanta, the governor of Georgia called out the State Patrol and the Georgia National Guard. No one raised an issue with that because that is a job of the National Guard to respond to the governor and provide for civil disturbance and support and riot control. Is really the same question I did to General Dean. Is that not understood by certain DOD officials that ultimately that is the same role as the DC National Guard? It's just the chain of command is differently since DC is not a state.
Yes, sir. The DC National Guard is unique in that aspect. In fact, there are actual DC code that gives special authorities to the DC National Guard that no other National Guard in the country have to conduct business within the district and conduct law enforcement operations in support of, federal or district agencies. I believe that General Dean is absolutely accurate. I asked the question, where was the chief of the National Guard Bureau in this when you were discussing Guard capabilities? You were only asking active duty military who had never served in the Guard, did not truly understand capabilities and authorities, and at no time you reached out to the 4-star general in charge of the National Guard to get information. Although you had all the information necessary if you just understood the role that had been delegated to you many months or even years prior to. I think it is incredibly important going forward that the Secretary of Defense, the Secretary of the Army, the Chief of Staff of the Army, to include the Sergeant Major of the Army, are thoroughly briefed on the authorities, capabilities, and their responsibility that has been delegated to them over the DC National Guard and its ability to respond to the nation's capital. We thoroughly train on our ability to be a reserve force for the active component. Why does the active component not thoroughly train on us?
Thank you. Appreciate the thorough answers there. Very important issue. I now recognize the full committee ranking member, Ms. Morelli, for 5 minutes for questions.
Thank you, Mr. Chairman. I'll admit I'm a simple guy, and I do want to do some follow-ups to Mr. Loudermilk's questions, which were important. Also recognize that General Walker was held such high esteem by members of our side of the aisle. We made him the Sergeant at Arms after January 6th. So I think we have as much faith in him and had as much faith in him as all of you did during that time. The way I see this, and maybe I'm wrong, if I'm the President of the United States, the Commander-in-Chief, even though I've delegated authority, I think at some period after 3 o'clock, when I see that there doesn't seem to be much movement, I'm going to pick up the phone and call the Secretary of Defense and the Secretary of the Army and say, exactly what's going on? Well, I've issued orders, or I haven't, or there's confusion. At some point, I would have had my Chief of Staff call General Walker and say, exactly what's happening on the ground. My only point is it would not have taken me, and I'm not sophisticated, but it wouldn't have taken me 3.5 hours while I'm sitting in the White House watching this unfold, confident in my view that while I've signed the necessary papers, so I'm not sure what's happening, but it's all good because I signed the papers. This is an attack on the United States Capitol, the citadel of democracy here in this country and around the world. So for all the other misdirection here, and I'm not suggesting that we're trying to bring the president into this unnecessarily. It's that the president is necessarily part of the chain of command. By the way, so is the Secretary of Defense, and so is the Secretary of the Army. So I'm not absolving them. They clearly had direct line responsibility to make sure this happened. And at some point, when this is going on, in the midst of the chaos, if only a few minutes goes by and something's not happening, I'm picking up the damn phone. I'm going to find out exactly what's going on. But to this point, so look, we have high respect, the greatest respect for General Walker. We would have continued him as Secretary or Sergeant of Arms. was my friends over there who make the decision to remove him, and that's fine. They have that responsibility. So let me ask this, and maybe, I'm not sure anyone can answer this, but let me direct it first to Sergeant Major Brooks. Tell me what the protocol should be going forward, since we're all focused on what's supposed to happen. Tell us in the future, whether it's January 6th, 2025, or any other day that involves a breach of the Capitol or issues here. What's the protocol? What should we know needs to be in place that people fear wasn't? How do we make sure this doesn't happen again? What's the protocol like?
One positive step that I believe has already been taken is I believe they've given the authority to the chief of the Capitol Police to call on the guard without further approval. That's a huge step. Secondly, I believe that the DC National Guard has been neglected for many years for what I believe to be the lack of knowledge or understanding. It was put on a shelf. Those who were delegated authority over, the Secretary of the Army, the Secretary of Defense, did not thoroughly understand their responsibility. You know, they're ultimately one of the commanders, one of the senior leaders of the DC National Guard. Over the 17 years that I served in the DC National Guard, repeatedly, the National Guard Bureau came down and removed units, military police units that would respond to the Capitol, have removed them from the DC National Guard without objection. If the governor of your state was told they were going to move one of their guard units, your governor would be upset and there would be a significant challenge to that, correct? The Secretary of the Army is supposed to be our governor. It's supposed to defend the DC National Guard from losing its capability to support and defend the Capitol of the United States. That has been neglected for decades, and it needs to change. The DC National Guard should be the elite unit that it was designed to be under President Thomas Jefferson. It is responsible for the seat of democracy. It's not responsible for a state, a territory. It's responsible for a city. It is the only guard that is responsible for a city. It just happens to be the capital of the most powerful nation in the world. And I think that's significant. And if that change does not come, if this happens again, and unfortunately in our political environment, I think there's a chance.
Well, and I appreciate that response, and I'm almost out of time. I would simply say this, that I also think leading up to January 6th, recognizing the tumult, recognizing the challenges, from the president to the Secretary of Defense to the Secretary of the Army, there should have been a lot of work in preparation for, not on that day, but in the weeks, months leading up, to make sure the lines of communication were set, and that there was a series of protocols that would be followed if and when things happened, and that clearly didn't happen as well. But again, gentlemen, appreciate all of your, not only testimony for being here today, but your long service and support of the United States. Thank you. I yield back.
The gentleman yields. Now recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
So I submit to you, gentlemen, that if the President of the United States had gone outside the chain of command and called General Walker directly, bypassing his acting Secretary of Defense and the Secretary of the Army, we might very well be in a hearing trying to find out why the President was interfering with the National Guard. Would you agree with that, Commander Sergeant Major?
I think that would have been a highly irregular.
It would have been highly irregular, Colonel.
Sir,
Yes, sir.
keep in mind, during that time, they were talking about the president improperly using the military. They wanted to take precautions against that use. So they wanted to have it both ways, to say he didn't call, but if he would have called, they would have said he was trying to interfere with the chain of command. So
That's exactly what I was hearing, and I just wanted to make sure we had it on the record. I put on the record previously in my previous line of questions that all of you were there with Major General William Walker from 1:49 p.m. through 5:55 p.m. During that time period, we've already established that he didn't receive any calls from Secretary McCarthy, but did he try to reach out to Secretary McCarthy during that time frame? Did you all witness any attempts by him to reach out?
Yes.
Not that I'm saying it's his duty, I'm just asking for facts. Captain?
Yes, sir. I witnessed John Walker attempting to reach out to the Secretary's office multiple times.
Multiple times?
Yes, sir.
Sir.
Yes, sir. Colonel?
In fairness to Secretary McCarthy, and I wrote a memo and I said he was incommunicado, and I wasn't taking a shot at him there. I was saying the Pentagon is a big building, cell phones don't work. If you're in a skiff in the Pentagon, you're not going to be reachable by cell phone. And if he's in a skiff with the chairman or with the secretary of Defense, it's reasonable he will not be able to be reached except through his front office, and the aide goes back and relays information. So I gave Secretary McCarthy the benefit of the doubt there.
And I appreciate that and appreciate you bringing, look, we're just trying to get the facts.
Yeah.
Brigadier General, my understanding is that you would have been second in command behind Major General Walker. Is that correct?
That is correct.
And if for some reason, because we heard earlier that as a part of the DOD IG report that that there were attempts to reach General Walker, which you all said didn't happen. But let's assume for the sake of argument that they couldn't reach him for some unknown reason. Wouldn't the proper move then have been to call you in this case of an emergency where orders have been given to activate the National Guard?
That is correct.
And it's interesting because the report says, and I'm not a military man, so y'all bear with me. I may be asking something that y'all all know and I don't. And that is that the Major General Walker indicated that he had called to initiate movement. Now, I understand there wasn't a call, but what does initiate movement mean? Does that mean to get into to go lend assistance? What exactly does that mean, Brigadier General Dean?
Initiate movement means that you actually give the order for a force to move. So in this case, it would have been our QRF or any force that was qualified to do civil disturbance. You give them the
So
order
that would have been the order to head to the Capitol
That would
and
have been
lend
the order to
assistance.
move, yes.
Okay. I mean, that's why I asked. I wanted to know. And Captain Nick, I think this is in the record, but let's just get it out there again. What time did the DC National Guard learn that they were authorized to deploy to the Capitol?
I wrote down in my notes 5:09 p.m., which was relayed from General McConville on a secure video teleconferencing line in our office.
5:09 p.m. Now, they've asked if the president, the questions from the other side indicated the president, if there wasn't any action, should have jumped the chain of command and called General Walker. But if you are Pyatt or Flynn, and you knew that there was supposed to be a deployment or initiate the move, wouldn't you have reached out to somebody if you couldn't get a hold of Walker? And I understand they were on the call the whole time, but wouldn't they have been able to properly call Brigadier General Dean? I'll let anybody answer, but
Yes, sir.
yes, sir. Sergeant.
Yes, sir. I
Sergeant Major.
think we miss a key point in all of this conversation when we're talking about who and what, when we go back to the significant fact that the only reason why we are here today is because Secretary McCarthy, in his approval letter, removed Major General's ability to execute his immediate response authority. Secretary McCarthy changed the memo from Secretary of Defense to the Secretary of the Army. The one that we got from Secretary McCarthy stated that Major General Walker could not deploy the QRF without the Secretary of the Army's explicit order.
I will just clarify, the term immediate response there is probably used incorrectly in this instance.
Immediate emergency response.
Yeah, so, but correct. Yeah.
And
I just
when
wanna be
was
clear, 'cause, you know.
and when was that memo or order given to not do anything without the direct call from the Secretary of the Army?
January 5th or 4th. I think the memos that
Several days before January 6th.
5th, sir. Yes, sir.
All right. I appreciate your questions. I appreciate you all. Thank you very much for your courage to be here today. I know that it's got to put you all under a lot of stress. I yield back.
Gentleman yields. Now recognize the gentleman from New York, Mr. D'Esposito, for 5 minutes.
Thank you, Mr. Chairman. Sergeant Major Brooks, at the time you were the most senior non-commissioned officer in the organization. Can you share briefly what was happening at the DC Armory between 3 p.m. and 5 p.m. on January 6th?
Immediately upon receiving the 149 call from Chief Son, we, the DC National Guard, on our own accord, initiated movement from the QRF from Air Force, Andrews Air Force Base to the Armory. So they were there. We were then taking the soldiers that were coming in for the second shift that were already at the Armory. We had geared them, fully kitted them with riot control gear. We had moved our transportation onto the Armory drill floor so that not to arouse any public awareness of what was actually going on. and they were loaded and standing by, ready to go. They had been divided up into civil disturbance platoons, roughly 40 to 45 people per platoon with appropriate leadership, which coincidentally matches the MPD force structure for civil disturbance as well, because as we've stated previously, we train with them, so we wanted to be as close to their force package as possible.
Right, you train with them to do the work that you're prepared to do, which is exactly the opposite of what so-called leadership was telling you your mission was.
Yes, but I think they like to say this untrained, and they point to us conducting him training, and some soldiers or airmen may have had their first experience of training. The Army and Air Force get brand new privates and airmen every day. They are assimilated into the formation and trained and trust that their leaderships have their best interest and would not put them in a situation that they were not prepared for. I believe that our leadership all the way down the chain prepared our soldiers and airmen as best as possible to perform the mission that they were given.
So on January 6th, between 3 p.m. and 5 p.m., they were trained, they were prepared, and they were ready to respond.
Absolutely.
Okay, thank you. Brigadier General Dean, according to his testimony to the DOD, Secretary McCarthy told to General Walker to, quote, posture his troops and, quote, get ready to go on the 2:30 call. Is that accurate?
That is not accurate. There was no mention. Well, first of all, Secretary McCarthy wasn't even on the call. I'll say this: he wasn't identified on the call, nor did he speak on the call.
Understood. Colonel Matthews.
Yes, sir.
If I leave anything out here, please correct me. You were acting general counsel to the Army.
Yes, sir.
You were principal deputy general counsel.
Correct.
You were deputy ledge counsel to the chairman of the Joint Chiefs.
Deputy legal counsel. Yes, sir.
Okay. You were special counsel to the director of national intelligence.
Was.
You served this country faithfully in combat in both Iraq and Afghanistan.
I did, sir.
You're a Nova grad.
Yes, sir.
All right. And you're a Harvard Law grad.
Don't hold it against me.
Pretty well accomplished. Let me ask you a question. You have 1 minute and 40 seconds, sir.
Yes, sir.
You were in charge on January 6th. Tell me your plan and what you would have done differently.
In charge of the D.C. Guard, the Army, the what, or what?
You could have made any decision necessary in order to keep this place safe.
I would have picked up the phone and told the D.C. Guard to deploy to the Capitol immediately, and I would have told General Walker to have everyone in the building kitted up in riot gear and get down to support Capitol Police. And I will say this, sir. At 3:04, Secretary Miller did give the Army authorization to go to the Hill. That was not conveyed to General Walker. So that authorization had been given. Secretary Miller had all the authority he needed. He didn't need to hear from the president. The president had given him the authority he needed to act. I would argue he had that authority even without talking to the president based on the executive order. So I think that there was a bottleneck, and it wasn't at the DC Guard level, and it wasn't at the OSD level, in my opinion.
Well, I guess, again, the goal here today was to make sure that we are better prepared next time. Brigadier General, you have one?
So yeah, can I answer that just real quick? So to me, what I would have done if I was in a position over at the Pentagon, I would have, or if I was the secretary, I would have given General Walker more latitude. I wouldn't have written a memo so constraining that it would take one person to mobilize the DC National Guard.
Well, that was clearly done by design.
Right. And secondly, what I would have done, I would have given him the authorization to deploy if there was a threat to life or limb. And then I would have said, when you get there, then give me a call and we'll discuss how the DC National Guard is actually going to be deployed. And
Well,
that's the con op.
My time's expired. I want to thank you all for your service to this great country. And thank you, Mr. Chairman. I yield back.
The gentleman yields. I've just got some closing questions, and then we'll adjourn after that. I just want to do a quick review before I ask these last couple of questions. From the information that we obtained from the Select Committee on January 6th, transcribed interviews, logs from DOD officials, we have a timeline of the authorization process of the National Guard. We know on January 3rd that President Trump ordered that the Guard be readied for potential deployment based on intelligence that had been received. As I mentioned earlier, Secretary Miller did testify to the Select Committee. He had full authorization to deploy the National Guard on January 6th, did not need any additional authority from the President of the United States. There was a breakdown in an order. Secretary Miller testified that he gave an order to deploy the National Guard to the Capitol. Somewhere there was a breakdown in that order, whether it was communication or a delay. Sergeant Major Brooks, if General Walker were to give you a direct order, you lawfully, and according to your oath, same oath I took when I joined the military, you were obligated to carry out that lawful order. Is that correct?
Yes, sir. Any moral, legal authority order given is my responsibility to carry out. Yes, sir.
If you did not carry out that order, would that be considered dereliction of duty?
Absolutely. And General Walker could take action against me. Yes, sir.
Do you feel that there was dereliction of duty in the chain of command on January 6th?
Not within the DC National Guard, sir, but from higher levels, yes, sir. I do believe that senior officials within the Secretary of the Army and senior officials in the Army staff were derelict in relaying the authorization from Secretary Miller down to the appropriate level of execution, which would have been Major General Walker, sir.
Okay. Thank you. I know that's hard. It's a difficult question, and I apologize for that. But to get to the truth, we need to know what really happened. Another, while we're here, and this is open to anyone that can answer this appropriately, and maybe I'll direct it to General Dean to start with. Secretary McCarthy claims that he was making a tactical level CONOP plan at the MPD headquarters. Did you ever see this plan?
Not only did I not see the plan, he was at the wrong agency. So the lead federal agency for this particular event was the Capitol Police.
Right.
So my question is why are you at the MPD headquarters and not at Capitol Police? Because the Capitol Police has a responsibility for the security of the Capitol.
Okay, that was my follow-up question, because the deployment was to the Capitol. So did General Walker ever discuss a plan with anyone?
Yes.
Okay, Sergeant Brooks.
Oh,
Or,
yes,
or
sir.
who, I'm sorry, whoever,
I was gonna
was
say-
that you? Okay, I'm sorry, Colonel.
Yes,
Yeah.
sir. If the plan was get your riot gear on and get on the bus and go support Chief Stephen's son at the Capitol. Take orders from any white shirt or senior officer in the Capitol Police Department. That was the plan. That's what we did. That's what we eventually did.
Okay, so, and we have Chief Sund here. Thank you for attending today, Chief, and for your service. Once the National Guard deploys, you become under the authority of the U.S. Capitol Police. You're sworn in then, right? You're officers of the U.S. Capitol Police. So your operation plan, in reality, I guess, is get from here to there, get sworn in, and do whatever Chief Sund tells you. Is that a good summary of it?
Follow lawful orders, sir. So the DC Guard never acts independently. We always take direction from civil authority. So we work for somebody
Right.
in the civilian side. So we would have taken direction from, that's what we did during the summer of 2020. We worked for the MPD all over the city, responding to riots in the city, or for the Secret Service Police or Park Police.
Okay, so just make sure I understand, there was a discussion of an op plan, very simple op plan, get on the bus, get to the Capitol, get sworn in and get to work. That's the
think-
extent of really an op plan that you need. Is that what you're saying?
Yes, sir. I
Sergeant
think that-
Brooks?
Yes, due to our normal planning operations, we already had a rally point identified for the soldiers who are on traffic control points within the city. All we had to do was communicate to those service members to rally at that point, don your riot gear. Everyone else at the armory would have been donning their riot gear and moving towards their direction. Exactly as Colonel Matthews mentioned, once we arrived, we fall under, it's called defense support to civil authorities. Once we arrive, we fall under we are supporting the civil authority. In this case, the Capitol Police would have given us direction on where to be and what to do.
Okay, thank you. This is my last question. And again, General Dean, I'll start with you since you were the senior member that would have been there at the time. The order that finally came at what time was it again?
5:09.
Captain Nick, 5:09?
Correct. I wrote 509 down in
Okay.
my wheel book.
General Dean, at 5:09, did Did Secretary McCarthy give General Walker the order at that time? If not, can you explain how you got the order?
My understanding is that General McConville actually gave the order, but he said he received it from Secretary McCarthy. And General Walker in turn told me, and I in turn told the quick response force, it's time to move.
Okay.
Sir,
Anybody else?
Sir, I was sitting right next to General Walker in the conference room in the BTC when General McConville was not in the chain of command, so it wasn't his order. He was conveying an order that we were authorized to go, and I was told that it came from not from Secretary McCarthy, but from Secretary Miller, that we had the authorization to go. That's what I was told at the time. And so this claim that Secretary McCarthy called General Walker obviously was not true, because as Secretary McCarthy has stated, it was not true. He did not call General Walker. That and the way we got it was relayed via VTC, a video teleconference.
Okay, so somebody called you up on video teleconference to give you that order
Oh,
then?
no,
or-
no. The conference was ongoing. It was running. And General McConville, Chief of Staff of the Army, happened to be on a conference talking to us. He mentioned that we had the authorization to go.
Okay, so he just was like, what are y'all doing still here? You're supposed to go? Or
No, he claims that, but that's not what happened, sir.
Okay.
Someone in the back of the room said, "Oh, these guys are good to go now. You're good to go." He said, "We're good to go." He claimed later that he asked General Walker, "Why are you still here? You already have the authority." That was not the case. General Walker did not. He implied that Walker had the authority 1635 from McCarthy. He was just hanging out on the BTC while twiddling his thumbs while the city was
okay
in the right condition.
Thank you.
Mr. Chairman, can I?
Yes, absolutely.
Can I add that it all doesn't make sense if you follow this through the chain, because if Major General Walker had been told numerous times, had been given a lawful order to do something, why was there never an action taken against Major General Walker for dereliction of duty or refusing a lawful order? There never was. There was never even an inkling of charging him with anything. So that whole narrative that we were just sitting around waiting is false. It's disrespectful to the men and women that did that job to think that we just sat and waited while the Capitol was under attack.
Sir, might point out, Walker told me that he was he wanted to send him anyway and resign. And I asked him not to do that. I said, "Sir, don't do that. Wait for the order."
He actually told me the same thing. So he said, he asked me, he said, should I send them? Should I send them? Should I send them? I'm going to send them. I said, don't send them. You didn't get the order. It's in writing that you can't send them. Don't send them.
Okay. I want to thank you all. I'm sorry.
I have something for the record.
Okay, I'll do these and I'll recognize you for that. Do want to enter for the record a memorandum from the Secretary of the Army dated January 4th, 2021, as the employment guidance for the District of Columbia National Guard. Also, letter from the Secretary of the Army to Major General William Walker, dated January 1, 2021, recommending approval of the request of Mr. Christopher Rodriguez, Director of District Columbia Homeland Security Emergency Management, on behalf of, this is support of the civil authorities of District of Columbia. Without objection, so entered. I recognize the ranking member.
Thank you, Chairman. I have a few items I'd like to enter to the record. Thank you. And I want to also acknowledge and say thank you to everyone that is here today. We know that the chaos at the Pentagon was caused by the Commander-in-Chief and the fear that he would involve the military in domestic political affairs. I want to enter into the record the following articles. A political article entitled "Trump Could Have Helped Response to the January 6th Riot, but Didn't," per new testimony.
Without objection.
A letter dated December 30th, 2022, and posted on the Select Committee website from the Select Committee to the General Counsel of the Department of Homeland Security related to the disposition of interview transcripts. Pages 99 to 101 of Acting Secretary of Defense Christopher Miller's interview with the Select Committee, an article from PolitiFact in which it declares the claim that the January 6th committee suppressed testimony from Anthony Ornado that proves former President Donald Trump pushed for 10,000 National Guard troops at the Capitol. A CNN article entitled "Trump's Defense Secretary Denies That There Were Orders to Have 10,000 Troops Ready to Deploy on January 6th. A Washington Post article entitled the false GOP claim that Pelosi turned down National Guard before January 6th attack, an email from Mark Meadows to John Akoff dated January 5th, 2021, in which he says that the National Guard will be activated so they can protect pro-Trump people. Appendix 2 of the Select Committee to investigate the January 6th attack final report and summaries of the many Capitol Police Inspector General reports requested by Democratic leadership of this committee last Congress.
Without objection.
Thank you.
Again, I'd like to thank each of our witnesses, the whistleblowers, for coming forward to share their story. Again, for anyone who is watching who wishes to share their story with my subcommittee, please do not hesitate to reach out at cha.house.gov/whistleblower-support. To our whistleblowers, members of our committee may have additional questions for you, and we ask that you respond to those questions in writing. Without objection, each member will have 5 legislative days to insert additional material into the record or to revise and extend their remarks. If there is no further business, I thank the members for their participation. And without objection, this subcommittee stands adjourned.
Conformance with the Article 1, Section 3, Clause 6 of the Constitution and the Senate's impeachment rules. Will all senators now stand and raise their right hands? Do you solemnly swear that in all things appertaining to the trial of the impeachment of Alejandro N. Mayorkas, Secretary of Homeland Security, now pending, you will do impartial justice according to the Constitution and laws, so help you God? The clerk will now call the names in groups of 4. Senators will present themselves at the desk to sign the oath book.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray. Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters. Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders. Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida. Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith. Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune. Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance. Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch. Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
Majority leaders recognized.
Any senator who was not in the Senate chamber at the time the oath was administered to the other senators will make the fact known to the chair so that the oath may be administered as soon as possible to the senator.
The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent under pain of imprisonment while the Senate of the United States is convened as a court of impeachment to consider the articles of impeachment against Alejandro N. Mayorkas, Secretary of Homeland Security.
Madam President,
Majority leaders recognized.
in a moment, I will ask unanimous consent to allow for debate time, to allow for Republicans to offer and have votes on trial resolutions, and allow for Republicans to offer and have votes on points of order. So, I ask unanimous consent that Senator Lee be recognized to offer a resolution that is the text of S-Res 624, the full Senate trial, that Senator Cruz be recognized to offer a resolution that is the text of S-Res 622, the trial committee, that there then be up to 60 minutes of debate on the resolutions, concurrently and equally divided between the two leaders or their designees, and following the use or yielding back of that time, the Senate vote on or in relation to the resolutions in the order listed, with no amendments to the resolutions in order. Further, that following the disposition of the trial resolutions, if they are not agreed to, Senator Schumer or his designee be recognized to make a motion to dismiss the first article of impeachment, that the motion be subject to only 7 points of order, that there be up to 60 minutes for debate concurrently and equally divided on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Further, that if Senator Schumer or his designee makes a motion to dismiss the second article of impeachment, that the motion be subject to only 1 point of order, that there be up to 60 minutes for debate, concurrently and equally divided, on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Following that further disposition of Article 2, the Senate vote on the motion to adjourn the Court of Impeachment sine die. Finally, that there be up to 4 minutes for debate equally divided between the two leaders or their designees prior to each roll call vote, all without intervening action or debate.
Is there an objection?
Madam President,
Senator from Missouri.
reserving my right to object. To dismiss or table articles of impeachment against Secretary Mayorkas without a trial here today or in committee is an unprecedented move by Senator Schumer. Never before in the history of our republic has the Senate dismissed or tabled articles of impeachment when the impeached individual was alive and had not resigned. As Senator Schumer said in 2020, quote, "A fair trial has witnesses. A fair trial has relevant documents as part of the record. A fair trial seeks the truth. Nothing more, nothing less." I will not assist Senator Schumer in setting our Constitution ablaze and bulldozing 200 years of precedent. Therefore, I object.
Madam President.
Objection is heard.
Madam President, I raise a point of order that impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional.
Under the precedents and practices of the Senate, the chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedents of the Senate, submits the question to the Senate. Is the point of order well taken? The Republican leader is recognized. Clerk will call the roll.
Ms. Baldwin.
So what you just saw there was the claim by Senator Eric Schmidt, Republican of Missouri, asking for a full trial when it comes to the impeachment articles towards the Homeland Security Secretary Alejandro Mayorkas. Then Senator Schumer, the majority leader, responding about raising the constitutionality of Article 1. And you'll remember that Article 1 is the refusal to comply with the law, going further saying that House Republicans accuse Secretary Alejandro Mayorkas of willful and systematic refusal to uphold the nation's immigration laws. Now, to get a sense of the Senate, that's the vote being taken place now. Again, we may expect more of this as the afternoon goes on. Those beginning processes already being done with Senator Patty Murray taking the oath of office as presiding officer, the swearing in of senators as judges, the signing of the oath book, and the proclamation by the sergeant at arms. So that's what's happening now as this vote takes place. Stay on C-SPAN 2 for more coverage. Again, we're waiting on the sense of the Senate through this vote on the constitutionality of Article 1. That was brought up by Senator Schumer, this after the response from Senator Eric Schmidt, Republican of Missouri, on his view, and other Republicans as well, for the need of a full trial when it comes to the Homeland Security Secretary Alejandro Mayorkas. Just to remind you what Article 1, Section 3 says about the role of the Senate in this process, saying the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath for affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than the removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Those are the technicalities from the Constitution. What fills in the blanks today is anybody's guess as senators debate these two articles of impeachment against Homeland Security Secretary Alejandro Mayorkas. Stay on C-SPAN 2, cspan.org, and our C-SPAN Now app for full coverage.
And we're waiting the results of this vote on a point of order made by Senate Majority Leader Chuck Schumer that the first article of impeachment against Homeland Security Secretary Alejandro Mayorkas is unconstitutional. He said because it doesn't allege an impeachable offense. Here's what that first article of impeachment says. House Republicans accuse Alejandro Mayorkas of willful and systematic refusal to uphold the nation's immigration laws. That's where we are at this point in the impeachment trial of the Homeland Security Secretary. It was Majority Leader Chuck Schumer who had laid out a plan that included some 2 hours of debate and then a vote on dismissal charges of this impeachment, but an objection raised by Senator Eric Schmidt of Missouri, the Republican, saying that he wanted a full trial held when it comes to the Homeland Security Secretary, and then Senator Schumer raising this point of order. That's where we are so far in this impeachment trial, awaiting the results of these votes. Live coverage here on C-SPAN 2. So here's where we are right now. The Senate is officially in a quorum call as senators are regrouping on the floor. As Politico Congressional Bureau Chief Burgess Everett put it on Twitter, there's a lot of confusion on both sides of the aisle right now. He noted that Senator Joe Manchin called over to a top Democratic floor staffer asking for help as they figure out what to do. Here's how we got here. It was Senator Chuck Schumer who laid out a plan for how the proceedings would go, including 2 hours of debate and an eventual vote on dismissal, a speedy impeachment trial, as Democrats have hoped to end this today. But it was Senator Eric Schmitt, the Republican of Missouri, who raised an objection calling for a full impeachment trial of Alejandro Mayorkas. And then it was Senate Majority Leader Chuck Schumer who raised a point of order to dismiss the articles of impeachment because he said they were unconstitutional, saying that there was no high crime or misdemeanor alleged in the articles that came over from the House. And that led to this current quorum call. Let's show you that exchange between Senator Chuck Schumer and Senator Eric Schmitt just a few minutes ago in the Senate.
Madam President,
Majority Leaders recognized.
in a moment, I will ask unanimous consent to allow for debate time, to allow for Republicans to offer and have votes on trial resolutions, and allow for Republicans to offer and have votes on points of order. So, I ask unanimous consent that Senator Lee be recognized to offer a resolution that is the text of S-Res 624, the full Senate trial, that Senator Cruz be recognized to offer a resolution that is the text of S-Res 622, the trial committee, that there then be up to 60 minutes of debate on the resolutions, concurrently and equally divided between the two leaders or their designees, and following the use or yielding back of that time, the Senate vote on or in relation to the resolutions in the order listed, with no amendments to the resolutions in order. Further, that following the disposition of the trial resolutions, if they are not agreed to, Senator Schumer or his designee be recognized to make a motion to dismiss the first article of impeachment, that the motion be subject to only 7 points of order, that there be up to 60 minutes for debate, concurrently and equally divided on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Further, that if Senator Schumer or his designee makes a motion to dismiss the second article of impeachment, that the motion be subject to only 1 point of order, that there be up to 60 minutes for debate, concurrently and equally divided, on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Following that further disposition of Article 2, the Senate vote on the motion to adjourn the Court of Impeachment sine die. Finally, that there be up to 4 minutes for debate equally divided between the two leaders or their designees prior to each roll call vote, all without intervening action or debate.
Is there an objection?
Madam President,
Senator from Missouri.
reserving my right to object. To dismiss or table articles of impeachment against Secretary Mayorkas without a trial here today or in committee is an unprecedented move by Senator Schumer. Never before in the history of our republic has the Senate dismissed or tabled articles of impeachment when the impeached individual was alive and had not resigned. As Senator Schumer said in 2020, quote, "A fair trial has witnesses. A fair trial has relevant documents as part of the record. A fair trial seeks the truth. Nothing more, nothing less." I will not assist Senator Schumer in setting our Constitution ablaze and bulldozing 200 years of precedent. Therefore, I object.
Madam President.
Objection is heard.
Madam President, I raise a point of order that impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional.
Under the precedents and practices of the Senate, The chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedence of the Senate, submits the question to the Senate. Is the point of order well taken? The Republican leader is recognized. Clerk will call the roll.
And that was just a few minutes ago on the floor of the United States Senate. And now we are in a quorum call waiting for a senator to speak. And we will see what happens together as the impeachment trial of Homeland Security Secretary Alejandro Mayorkas continues this afternoon. You're watching live on C-SPAN 2.
Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Brett. Mr. Brown. Mr. Budd.
This quorum call continues in the impeachment trial of Alejandro Mayorkas. We're waiting for a senator to speak. You're hearing the roll call of the names of the United States senators as they go through this quorum call, even though there's obviously a quorum on the floor due to the earlier productions of this impeachment trial. As we await a member of the Senate to speak, we are going to talk with Alex Bolton of the Hill newspaper, who's watching this as well. Alex Bolton joining us on the phone. Good afternoon, Alex Bolton. Explain where we are and why this is a quorum call, despite what we heard from Senator Schumer not too long ago.
Ms. Cortez Masto.
Basically to buy time on the Senate floor so Republican senators can figure out how to respond to Schumer's move right here. Schumer is raising a point of order that the first article of impeachment is unconstitutional because it does not allege a high crime or misdemeanor. That's the standard set by the Constitution. Patty Murray, as you just showed, says that she doesn't have the power to decide that question. She's now going to ask for the Senate to vote on whether Schumer's point of order is valid. If the Senate votes to sustain Schumer's point of order, it effectively dismisses the first article of impeachment. Then Schumer will move forward with a point of order, similar point of order against the second article of impeachment. If that's then sustained by a separate vote, both charges will be dismissed and the Senate trial will be effectively over.
So this could essentially become an even speedier trial than what Senator Schumer was offering in that original statement that he made?
Well, what Schumer offered was to set aside debate time to give Republicans an opportunity to vote on some trial resolutions. sponsored by Mike Lee and Ted Cruz, to basically either hold a full Senate trial or to refer the impeachment to a special committee. But as you saw on the floor, freshman Senator Eric Schmidt, Republican of Missouri, he objected to that unanimous consent agreement. So because of that, there is no structure for the trial, and Schumer is moving ahead with a point of order, basically to declare the articles of impeachment unconstitutional. What's interesting here is that Schumer is raising a point of order to dismiss the charges. By doing so, Republicans don't have an opportunity to offer their own points of order. He is preempting them here, so they really can't do much in way of protest or to drag the proceedings out if, in fact, this point of order is sustained.
And are point of orders a simple majority vote in the Senate?
Yes, under Senate impeachment rules, all matters are decided by majority vote, except for conviction or acquittal. As you know, that requires 2/3 vote of the Senate to convict or remove a federal officer from office.
Coming back to Eric Schmidt's objection, was that expected? Do you know?
Well, they've been trying to work out a deal on, debate and, voting on trial resolutions since yesterday. And it looks like that almost everyone was on board except for Schmidt. And Schmidt told reporters downstairs shortly before the vote that he would not agree to the UC. So at the time he objected, it wasn't a surprise, but that was something that was revealed by Schmidt only a short time before he objected.
As you know, the camera's controlled by the Senate, and we have sort of the high shot of the dais here. Did you get a sense of what the reaction was to Schmidt's objection and Chuck Schumer's response and offering this motion in response to that objection?
Well, I mean, from my colleague Al Weaver, who is in the chamber, he sent me some color and said that, after that happened, senators immediately started to huddle and figure out next steps. There was a huddle on the floor between Senate Republican Whip John Thune, Ted Cruz, Mike Lee, John Kennedy, and McConnell's chief of staff. John Cornyn, who's hoping to become the next Republican majority leader, he was part of those conversations. So there was certainly some frenzied huddling on the floor. And, in the meantime, John Tester, who's a critical vote here, ran over and snagged a bag of peanut butter M&Ms out of Cory Booker's desk. So that's some of the floor activity. I think, look, the outcome is a foregone conclusion. There's not going to be a Senate trial. So I think senators are just waiting for this to be over with.
TheHill.com is where you can go to read Alex Bolton's reporting and that of his colleagues. Always great color in The Hill. Thanks for filling us in, Alex Bolton.
Thanks for having me on.
Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden.